Down in the shadows where the courthouse stands, a gavel cracks a fading hands. Judge Gould, they whisper with a crooked grin, played the game where justice don't win. Free Rick Allen, let him go. Chains on the innocent, don't you know? When the truth's been buried and the lies unfold, the fire in the people burns hot and cold. Prosecutor Mickelin with his papers tight wrote the tale that never saw light. Twisted words in a room of stone left Rick Allen to stand alone. Who will answer? Who will pay? The sun don't rise on a judgment day. Free Rick Allen, let him go. Chains on the innocent, don't you know? When the truth's been buried and the lies unfold, the fire in the people burns hot and cold. Officer Holman, eyes like frost, drunk on power, the line got lost. Lock the doors, keep him inside, for justice limps where his footsteps stride.
Hey, yo, folks, and welcome to this Sunday. I was supposed to do this stream Saturday, but I was slightly hungover. Thank you for all. Thank you for your support, your monetary support on Friday during my slightly buzzed, which became heavily intoxicated Friday last stream. Thank you, guys. So I had to take yesterday off and use that as my day off. Oh, how are you all doing? How are you all doing? And yeah, we are continuing the reading of the Delphi Trial Transcripts today. But first, I got a message from Rosalind Duke, because she found a little something. So this, folks, will be, hold on while I do this first. This will be who wore it better. You might be, what? What do you mean who wore it better? Well, Mike, Law Talk with Mike, did a little something that I have been known for. Let's check it out. Let's check it out.
Crusaders and Brecken, but they're also at fault for this. I'm not happy about it, but this is the abuse I put up with. I said in no uncertain terms, I'm not doing this, and then they just do it with AI. There's no respect.
So, folks, who wore it better? I haven't worn this on stream since the YSL trial. I barely have the... There you go. To protect my hair, I have a bonnet. Yeah. Now I don't have his fancy pointy bonnet because I actually have long hair. So, folks, who wore it better? Me or Mike? Me or Mike? Who wore it better? So, let's have a... let's put out a poll here. Who wore it better? Now, I know you might be slightly biased, which I encourage. But, yeah, who wore it better? Who wore it better? Who does it fit better? Me or Mike? Mike, you know I love you. This is a free throw. You can't post that thing and not expect people to take advantage of it. All right. Yeah. And since I'm already in the lead in the poll, I'm going to end the poll. And the winner is me with 78% of the votes. Yes, it has been concluded. Who wears a bonnet better, me or Mike? And it is me. Thank you, Rosalind Duke, for sending this one over. Oh, I'm having way too much fun with this. Oh. All right. Yeah, fastest poll ever. Yep. Nick is literally Santa. Well, yeah. Oh, I went on Vice Baby yesterday, his stream, and he had Mrs. K Grift on. Oh, she came in the. She went. She arrived at the at the stream, and her daughter was still awake. And Mrs. K Grift's daughter, 2 years, I believe, she has said, "I'm Santa," and it's the sweetest thing ever. It is the absolute sweetest thing. She's so Mrs. K Grift. She doesn't show the daughter, but her kid goes, "Hi, Santa," and it's the sweetest thing ever. But of course, I'm Santa. Of course, I am. I have people telling me the next time I'm going to the United States, because as you might know, I'm going there now in September. I will be landing right about now in a month. Next time, I should go around Christmas and try to make some money, because Scandinavian Viking Santa, who doesn't want to have a visit from Scandinavian Viking Santa? Maybe even ask somebody in Vegas, "Hey, you can have a show about this." All right. Let's get back to what we are actually here for, which is the Delphi Trial Transcript. We left off with the absolute sham that was the disqualification meeting in Judge Gull's chambers, where she gave Rozzi and Baldwin the option: either you recuse yourselves voluntarily, or we're going to go out there where I have prepared media. There's video cameras. The only time she had video cameras in the courtroom with a live stream, and she would rim them out to no end, probably trying to end their careers. So, but which we saw on Friday. And then we saw the Indiana Supreme Court hearing about this. And yeah, they came back really fast with the decision that no, Judge Gull, you can't do this. Sadly, they didn't find reason for her to recuse herself, which I mean, when the Indiana Supreme Court in one decision says she didn't follow the law, she made a reckless ruling. I mean, they were really harsh, but still allowed her to continue to preside over this case. Boggles my mind. But it was a win, and you have to take the small wins, even though, because once the Indiana Supreme Court said this judge doesn't know how to follow the law, well, that kind of tells you everything you need to know about her conduct in this case and trial. Altogether, tells you everything you need to know. Yeah, there are guys that make bank at Christmas time. Yeah, I might reach out to some people and see, because I do know some areas do have a Santa organization or Santa union even, but I don't think that exists in Vegas. So who knows? I mean, I have tons of stories I can tell. I have Swedish folks and fairy tales, and I have well, not that one. I have nope, not that one. Well, I have books. I have storybooks. I mean, I have storybooks that are where the stories are, well, let's just say they are several hundred years old, so no copyright. I even have a channel where I read some of them. It's called, hold on while I get you the link for that one. Here it is. No, I haven't posted for quite some time over there, but there is like 20 stories I read in. That is 20 stories. Hi, Rosalind. There you are. Hey, thank you. So yeah, I posted. This is the link to my storytelling channel, and I had it's 20 stories there. I haven't posted anything there since Christmas, but I mean, it's still stories there if you want them. I might get it up and running again properly when I have time for it, which I don't. But all right, yeah. This is what we are here for. Record of hearing held on October 31st, 2023, with the new attorneys. Volume 3, page 34. Appearances for the state, McLeland and Luttrell. For defendant, William Lebrato and Robert Screamin. And as you might not know, Judge Gull personally appointed these two attorneys. One of them had already been on a show on TV, publicly saying he believed Rick Allen was guilty. The other one was a Facebook friend of Judge Gull. And you might also know, but I might as well repeat it. After Baldwin and Rozzi was reinstated, one of them got on an interview and said that they were fully behind the Franks motion about the Odinist theory. So anybody who says, oh, it's a scam that the defense made up, no. Everything about the Odinist theory came from the state. Everything. And they tried to hide it from the defense, but they found out anyway. So not one set of attorneys, but two sets of attorneys was backing this Franks motion. But this is from October 31st, just 12 days after the disqualification. So let's see what happened here. Judge Gull and reporter Jody. Oh yeah, and we are currently at 19 inaudibles so far. 19. Proceedings. The court. We are on the record. Thank you, Karen. All right, are we ready? Is the state ready? McLeland says, yes, Your Honor. Luttrell, yes, Your Honor. The court defense ready? Lebrato and Rozzi? That can't be right. Why does she have Bradley Rozzi there when the attorneys are Lebrato and Screamin? Well, that tells us all we need to know how much attention she has on this. The court. We are on the record in State of Indiana versus Richard Allen. I'll show that the state is here by Mr. McLeland and Mr. Luttrell. Defense is here by Mr. Lebrato, Mr. Screamin. And I note yesterday late the written appearance by Mr. Rozzi and Mr. Baldwin. Oh, so they were there. Okay, sorry. Mr. Lebrato, earlier this morning, you filed a motion to continue the jury trial. Lebrato, that's correct, Your Honor. Go ahead, sir. I explained that to Mr. Allen. Okay, and what is the state's position? Judge, the state has no objection as long as the time is chargeable to the defendant. The court, okay. Lebrato, and Your Honor, that's in our motion that we would accept all the CR4 time. Yeah. So this is them basically ruining the speedy trial for Mr. Allen. And the new defense attorneys, they don't have any choice. This is forced by the prosecution and Judge Gull. They didn't have any choice. The court, yeah, I show in paragraph 4, the state doesn't object as long as CR4 is charged to the defendant. Okay, so then we have the appearances by Mr. Rozzi and Mr. Baldwin. Gentlemen, Attorney Baldwin. Judge Weir, Mr. Allen has asked us to represent him, and we entered our appearance to represent him. The court, okay. Well, as we had our hearing on the 19th, prior to that hearing, we had some discussions. Counsel, you withdrew. You chose to withdraw from the case, rather than be removed for gross negligence. What changed in 12 days? Mr. Rozzi, well, Judge, I think I made it abundantly clear in my pleadings with the court that the conduct of the tribunal in chambers a week and a half ago left us with no choice but to withdraw, because we're going to put ourselves in direct conflict with our client by sitting in the courtroom and accepting, what was a lashing, essentially, from Your Honor. And so that was a strategic move, so as to protect our client's rights. And I think I made that abundantly clear. I don't know how that couldn't be clear at this point. Beyond that, us transitioning from contract public defenders to private counsel puts us in an entirely different situation with our client. Yeah. After she removed them, they went in and said, we are going to do this pro bono as private counsel. That is how deeply they felt about Rick Allen in this case. They were prepared to go pro bono. And that is very, very unusual. Especially since at this time, Judge Gull haven't paid them anything of their public defenders' fees for, I believe, since April or May. He stopped approving their bills. His Sixth Amendment right to have representation. And to the extent that the court is trying to intervene into that right without some due process, it's my client's contention that that's not appropriate, and he has his right to have counsel of choice. So I don't really know that there's much else to say. I think in the normal course of business, I'm a private practitioner. I was once a public defender. In the normal course of business, and in every other case I've ever been involved with, when there's a public defender assigned to a case, such as Mr. Screamin and Mr. Liberato, excuse me if I messed your name up, the same for me. But in every other case, when private counsel enters their appearance, the public defender taps out and basically private counsel gets up and running. And I don't see why this case should be any different. The court, well, again, you haven't answered my question that nothing has changed in the 12 days since I found gross negligence on the part of the defense representing Mr. Allen. Mr. Rozzi, well, the answer to the question is that we didn't act grossly negligent. And the court has an opinion that's different than our opinion. And, at this point, without some due process and some findings, with a notice, an opportunity to be heard, that's where we are just on a different page about how we acted and what our circumstances are. So that's the answer to the question. The court. Does the state have any opinions or wish to weigh in? Yeah. What Rozzi and Baldwin are trying to do here is to be reinstated so they can file their speedy trial notice. Mr. McClellan, Judge, I guess I'm at a loss at this point. We struggled up to this point, Judge, and again, I was there in chambers in the meeting. I agree with the statement made by the court, of course you do, about the defense being grossly negligent. Of course you do, you fucker. You've just been exposed through the Franks motion that almost everything you did in this case was at best incompetent, but more probably it was just you, Mr. McClellan, doing illegal shit. Oh, Scribrato? Oh, Again, this started back at our first hearing back, I believe, in November, with the actions outlined by the court about defense statements in chambers, and then a kind of direct 180 from that statement once they left chambers. And then there was a leak from the defense in December that wasn't made aware to the state or to the court until the state found out. That's bullshit. That was a press release in response to your actions, Mr. McClellan. Then we have the various motions that were filed with not only negligent statements, Judge, but I think outright lies. They're talking about things in the Franks motion. They are talking about things about Mr. Allen, what he was subjected to in Westville Correctional Facility. We now know those weren't lies. That was just the prosecution with their head buried inside Judge Gull's hoo-ha, just making shit up to make it stick. And from everything I've heard about Judge Gull, Everything about her sticks. Or stinks. Sticks or stinks, whatever it is. And we then have the Franks motion that was filed, Judge, that what you have to outline in a Franks motion is very clear, and the defense spent over 100 pages outlining their theory of the case instead of argument for the Franks, which you can do. And again, I think everything they've done, including the most recent leak, is just an effort by them to push this case out into public and try this in the public eye and not in this court. You mean First Amendment? The public has a right to know? The state's concern is that Mr. Allen has a fair trial. It was never fair. You know why, Mr. McClellan? Because Judge Diener's protective order that put Mr. Allen in prison instead of jail, in my opinion, was an ex parte meeting. Illegal on its face, improper on its face. Because you didn't notify Rick Allen's attorney at the time about this meeting. You didn't notify Rick Allen about this. Then you represented to Rozzi and Baldwin that it was properly held. But you never told him, no, never told Brad and Rozzi that you never told Rick's attorney at the time. But that goes both ways. We deserve a fair trial too. No! No, I hate this. I hate this with a passion. I hate this with an absolute passion. The state does not have a right to fair trial. They have an obligation to conduct a fair trial. There's a clear difference. Clear difference. And I hate every single time I hear a prosecutor say, we deserve a fair trial too, because there is nothing in Constitution, Bill of Rights Amendment that says the state have the right to a fair trial. Because the Constitution, Bill of Rights, and amendments are all about what the state cannot deprive of its citizens. They are not rights given to the people. Those are things that outlines what the state cannot take away. All right, let's continue. And I don't think the actions by the defense can be attributable to anything else but gross negligence, Judge, and so that's the state's opinion. Luckily, the Indiana Supreme Court said it's not. You're wrong. The court, Mr. Allen, I understand that you wish to have Mr. Baldwin and Mr. Rozzi represent you in this matter. I have grave concerns, Mr. Allen, about the representation of you, their previous findings by the court of their gross negligence. Mr. Allen, you are entitled to adequate representation in your case. You're entitled to a vigorous defense in your case, which you are actively denying him, Judge Gull. And this is difficult, Mr. Allen, because I know what you want. You indicated that through your attorneys, but I cannot and will not allow these attorneys to represent you with the concerns that I've had, with the gross negligence that I have found. You never found it because there was never an evidentiary hearing. It was you putting yourself above the law. You are not above the law. Sadly, the judiciary in Indiana allows you to put yourself above the law. I can't wait for the day that I find out that you have been in pain your entire life, and I will laugh at it, Judge Gull. They withdrew rather than be found grossly negligent to be removed. I can't do it, sir. I just can't. I have, Mr. Baldwin, Judge. Court, let me finish. I cannot allow that. I have appointed able counsel to represent you. Mr. Screaming here, Mr. Lebrado is here. They have an investigator here as well, and I will grant their motion to continue your trial. So no evidentiary hearing over this as well. Yeah, as Orthodox says, grave concern have been code for judicial misconduct. Yeah, well, I mean, that's for Judge Bev and Judge Gull. Every time they say, I have grave concerns, and it's only directed towards the defense, you know that it's just BS. It's just bullshit. I know that you have not talked with the state. I know you have not yet received discovery. There is no way that you can tell me when you will be ready for trial. I've asked former counsel to cooperate. I've asked former counsel to provide the discovery to you. It's my understanding that, Mr. McLeland, you've indicated that that has not been provided to you. That doesn't stop Mr. McLeland from re-giving, because they still have all the discovery. They could just say, this is what we sent to them, let's send them to you. But no, what Mr. McLeland is doing here is that he's waiting for everything to come back from Baldwin and Rozzi, so he then can resend that one. Which, fucker. Mr. McLeland, correct, Your Honor. The court, gentlemen, when can I expect you would return the discovery to the state of Indiana? Baldwin, by the end of the week, perhaps today. The court, that would be great. If you could get it today, that would be wonderful. Then that can be provided to successor counsel. Nothing stopped the prosecution from, all right, here's the new attorneys. Here's what we send the other guys. There's nothing stopping them from doing that. You're not required to cooperate with successor counsel. I would hope that you would, in Mr. Allen's best interest, but that is entirely up to you. If you could have the discovery to the state by the end of this week, that would be great. I know that I previously entered an order that discovery was to be complete by November 1st. Obviously, that's not going to happen. Do you want to pick a trial date, Mr. Lebrato, Mr. Screaming? Mr. Lebrato, yes, Your Honor. Briefly speaking with the state, tentatively, we would like a trial date in November. Over a year later. But not knowing what exactly we're going to be getting, I can tell the court with any certainty that we will be ready in November. We will do everything in our power to be ready by then. It's my understanding that it's a massive amount of discovery. The court, it is. Karen, I know that you brought the calendar. Could we get a date in November? Okay, I'm looking at November of 2024. There's an election day, there's a Veterans Day, and then Thanksgiving. Mr. Lebrato, if October or December would work better, the court, October? Mr. McLeland, that's fine, Judge. The state, whatever is fine with the court is fine with the state. Mr. Screaming, Mr. Lebrato, Attorney Screaming says October would be fine, Your Honor, for a start. The court, then why don't we look? October 14 is marked off. What is that? Columbus Day, Your Honor. Columbus Day. You may mark that off. So we'll look at October 15th through the 31st. Yeah, this is when she indicates that it's just 2 weeks, including jury selection. 2-week trial, including jury selection. And she basically told the defense, I believe it's in later hearings, we will get there, but she more or less gave the state unlimited time, and then she gave the defense a limited time to present their defense. McLeland, fine, Judge. The court and we, again, would pick the jury in Fort Wayne and bring them here to Carroll County for the trial. There's a pending motion to suppress. There is the Franks that is not yet. I haven't finished even reading it or go through it. All of the hours of interviews that were provided on a flash drive. The Franks motion was submitted September of 2023. And then, yeah, we're going to get into that later as well, but just as a spoiler, she denied every Frank's motion without a hearing. Every single one. Which is so improper. And then she denied the third-party culprit because she claimed it was no nexus. She claimed, despite people confessing with actual details that only the killer would have known, people without an alibi, with confessions, she deemed there was no nexus. Oh, I hate this so much. Every time I read this, it takes a bit of my soul away, but it needs to be read. Once we get to the actual trial transcript, hopefully I will get a few people here so we can reenact it, some of it. But I also know that some people have put all the transcript through an AI voice. So maybe that will make it easier, but I actually prefer to read it. Yeah, and the DNA. Yeah. Unknown male DNA on the victims. And then Elvis Fields, who said, if my spit is on the victims and I can explain it, am I still in trouble? That's a fucking nexus, Judge Gull. So she had the Frank's motion, the first Frank's motion, for 2 months now, and claims she haven't read it. Once you get the discovery and once you have the opportunity to review the pleadings, you could either adopt those pleadings or make your own. It's up to you. Anything else from the state? This is something that is puzzling me because it seems like she was absolutely prepared to hear about the Frank's motion from the new set of attorneys. And then once the old attorneys was reinstated, she just, nah, I hate these guys, so I'm just going to deny it without a hearing. For the love of holy, I don't pray a lot, but whatever powers there is, make her homeless. Make her shunned by her family. Then at Judgment Day, please put just a few seconds me beside Mr. Allen where we can point at Judge Gull as she descends into hell, so we can point at her and laugh at her. Judge, Mr. Baldwin. Judge, we want to create a record to be clear on what you're doing. You're disqualifying Brad and me, is that correct? Court, correct. Mr. Baldwin, we would like to be heard through my attorney, David Hennessy. The court, sure. Attorney David Hennessy. Oh, this is good. Good morning, Your Honor. I do have a limited appearance on record, which hasn't been removed or disqualified. The court has my preliminary memorandum about disqualification when Mr. Rozzi and Mr. Baldwin were appointed counsel. This is yet different. The law that I gave the court is even more certain. The court appears to be saying that it's protecting Mr. Allen, but the court's findings of gross negligence was summary, without notice, without the opportunity to be heard. Had you given Mr. Rozzi and Mr. Baldwin notice on your intentions on November 19th, when they were formed, which seems to be like a week earlier, then they could have been prepared. I can tell you on the behalf of both of these gentlemen, you would have the Indiana Public Defender Council come testify. You would have competent attorneys from across the state come testify. You would have defense counsel that have been declared experts in criminal defense. Mr. Baldwin's one of a handful of lawyers in the state that is certified in criminal defense. So your summary ruling violates the Constitution, and your summary ruling is unfair to everyone, especially Mr. Allen, because he was never able to make a record. Your finding of gross negligence, what you cited to them in chambers, which has never been put on the record, is not gross negligence. It is zealous representation. maybe too zealous for the court's favor, but it was good lawyering. The memorandum on the Franks issue is a work of art. It is legal writing at its best. The court, this has nothing to do with the Franks issue, sir. Mr. Hennessy, no, but that, the court, nothing to do with that, so please stay. Mr. Hennessy, no, it has to do with your finding of gross negligence, and what I'm citing to the court are the activities. The court, I never mentioned the Franks. I'm sorry. Never mentioned the Franks hearing, never mentioned the motions, sir. Okay. You mentioned the transport orders. Unfortunately, the public and I was not allowed in representing Mr. Baldwin. And unfortunately, the public and I aren't privy to the recording of the session outside the presence of Mr. Allen. He has a right to be present at every critical stage of the proceedings. When the court coerces a withdrawal or quitting, that's a critical stage of the proceeding. He wasn't present. And I'll be happy to address each and every point that you think constitute gross negligence. I've practiced criminal defense for 40 years. I understand and know in detail what these two lawyers have done on behalf of Mr. Allen has been nothing but zealous representation. So thank you. I have no expectation you'll change your mind for allowing us to make a more complete record about your finding of gross negligence in the disregard of Mr. Allen and unfairness to Mr. Baldwin and unfairness to Mr. Rozzi. The court. Thank you, Mr. Hennessy. Thank you, Judge. This is in preparation because what happened inside her chambers was not on the record. So this is Mr. Hennessy making a record of that there was no record. So Judge Gall's findings were not on the record, and as such, and I believe that as well was a part of the findings of the Indiana Supreme Court, that everything she did regarding the disqualification was illegal. Mr. Hennessy, thank you, Judge. The court, anything else from the state? Mr. McLennan, no, Your Honor. Mr. Screaming, no, Your Honor. Thank you. Mr. Lebrato, no, ma'am. All right, thank you very much. We set a trial. We are in recess. That concludes the proceedings. October 31st, 2023 in this case. Autolog, so there were no findings of gross negligence? No. No, well, she did make findings, opinionated, but those were off the record. Then she went on the record without hearing, without an evidentiary hearing, and made a claim. And that's not the law. And that was also, I believe, what the Indiana Supreme Court found, that everything in that was done improper. And such never happened according to the law. All right. Next one. Record of proceeding on hearing for motion for contempt held March 18th, 2024. Nothing happened between October 31st and March 18th? Of course it did. Motions after motions after motions after motions. But these are the transcripts from the hearings. That's why you get these distances. So how did the Supreme Court find on the Franks issue? They didn't. They didn't make a finding on the Franks issue. The only finding they got was about this disqualification, and if this was enough to disqualify Judge Gall. So the Franks motion was never up there, I think. Hold on. Nope. No, that was never up to Dizzy Jezebel. To this day, I don't think Gall read the Franks memo. No, none of it. because she didn't like the attorneys. And when she doesn't like the attorneys, she doesn't care what they put in writing. She just denies it without a hearing. Because if she allows a hearing, then she have to make an active ruling and explain the ruling. And she didn't want that because she's a cunt. Okay, March 18th. Motion for contempt held March 18th, 2024. Appearances. Nicholas McClellan, and here comes Stacey Diener, who is somewhat related to Judge Diener, which should have disqualified her from being appearing here. And Rozzi and Baldwin are back. This is after they were reinstated. For Rozzi and Baldwin, Hennessy. So this is when Judge Gull tries to have them in for contempt. Proceedings. State of Indiana versus Richard Allen. We are on multiple pending motions. I think the first motion I set was the state's motion for leave to amend its charging information. McClellan. Yes, Your Honor, Your Honor. Before we get started, I'd like to introduce the Court Deputy Prosecutor Stacey Diener. We brought her on board to help assist with the case and try the case. I was notified today that a tradition, at least in Allen County, to enter the appearance for the Deputy Prosecutor. So I'll follow this up with a written appearance today, Judge, after the hearing. Okay, good morning, Ms. Diener. Ms. Diener, good morning. Mr. McClellan, Judge, the state has filed an amended count or an amendment to add counts and would like to add counts 3 and 4. The state's going to make an oral motion to dismiss counts 5 and 6. I think there's an argument to be made that those are allowed to be filed outside of the statute of limitations. But given that we are past the 5-year mark on those, Judge, I think it's appropriate to dismiss those two. And so the state's not going to go forward on count 5 and 6. So the amendment is just here to add counts 3 and 4. We believe that's allowed. We believe that's appropriate at the time. Those counts better match the discovery that we submitted to the defense and better match the probable cause that's been filed with the court. We did that. We filed those counts in plenty of time for the defense to prepare for trial. We believe it's allowed under the statute, and we'd ask the court to grant the same, allow the court leave to file those additional counts, Judge. The courts, Mr. Rozzi, Mr. Baldwin, Judge, we have no objection. The court, then I will show without objection, counts 3 and 4 are added, and I will grant the state's oral motion to dismiss count 5 and 6. Do you waive initial hearing on those alleged counts? Yes, ma'am. Thank you. That takes care of that. The next motion then, that was set by the court, and I don't know if we want to take this up or if it's what everybody's position is. The states file a motion for all future pleadings and filings to be sealed for the court's review before being released to the public. Still trying to hide. Mr. McClellan, Judge, that motion was filed, I guess, prior to the last hearing that we held back in October. I can't remember the day, October 17th, I think. At this point, Judge, the state's going to withdraw that motion. I have forgotten it was filed and still pending, Judge. I apologize. Okay, that's fine. I just want to make sure we're clear on the record. You have, Jesus Christ, Judge Gull, you don't care about the record because it took months before you put anything up on the thingy. So the public knew what you have decided. So I'll show that's been withdrawn. I know that the defense in the contempt proceedings filed verified emergency motion. Did you get those orders to them? Court reported, yes. The court. Okay, so you got the orders where I've denied the verified emergency motion for a continuance, the supplement motion for continuance, and I think that was it. So that's been resolved. Yeah, without a hearing. I'm not sure, Mr. Hennessy, on March 12th, you filed a motion to stay all ancillary proceedings and get this case to trial. I'm not sure, and I know the state filed its objection to that. Do you wish to be heard further on that? Hennessy, no, Judge. It just makes perfect sense in my mind. The court, it just what? Hennessy, I'm sorry. You said it make perfect sense. Mr. Hennessy, yes. This is snark. By the way, this is snark. Court, anything further on that then, Mr. McClellan? Mr. McClellan, no, Judge. Just note our objection. We continued this hearing once before to give the parties ample time to prepare. The state's ready to proceed forward, Judge, today, and so we prefer to proceed forward today, Judge. The court. And we will proceed forward. So I'll note the motion, deny it without hearing. Of course you do. I understand that you've indicated, sir, in paragraph 4, that this hearing will last at least 1 day and probably 2. I have scheduled this for 1 day, so you'll need to conduct yourself appropriately to make sure that it gets done. Defense has also filed a motion for specific findings of facts and conclusions thereon. That obviously going to be granted, and I will make findings. Defense also filed an objection of change of venue. I noted your objection, Mr. Hennessy. This is Hennessy to the change of venue. The court, yes, sir. Mr. Hennessy, okay. Will the court be inclined to identify any exceptional circumstances that's referenced in the rule? The court, no. Mr. Hennessy, okay. The court, I've noted your objection. It wasn't filed until March 12th. This matter has been pending since, I think, January, when the state filed its verified information for contemptuous conduct, January 29th. I set the first hearing in February. That was continued on to today on defense motion. That was continued without objection, so I don't find it's timely at this point. But based on your concerns and your objections, all future hearings, if there are any, outside of the trial, will be conducted in Carroll County. Just reminding counsel that you have all agreed to conduct jury selection here in Allen County with an Allen County jury. And then the final motion that I have pending is a verified petition for recusal of the prosecutor from contempt proceedings. Mr. Hennessy, yes, thank you. Oh, wait. I think he's a necessary witness, and I've explained to him that I've explained why I think he's a necessary witness. In particular, we're going to have evidence that there's a Gary Baudet that goes by Fig Sauce, and a few other handles, and that he and Mr. McClellan were exchanging communication and information. We'd like to know what that was. Yeah, we're going to get to that. Hi, Sleuthy. Sorry, didn't see you there. I'm very, very caught up in this. I'm very, very caught up. Hello, by the way. Hey, Derek. Hey, Derek. Micah's headphones. This is Jezebel. Autotalk. Everybody here, and everybody over at Rumble as well. Everybody over at Rumble, you're so welcome. Thank you for being here. We'd like to know what that was. There were other leaks that we've investigated and have become aware of, and were not investigated. And those leaks were more substantial than the allegations against attorneys Rozzi and Baldwin. For instance, there were 2 leaks of probable cause affidavits. The sealed probable cause affidavit that has submitted in support of the charging information, which has details of the investigation. Then there was a leak of the affidavit for probable cause to search Mr. Logan's property, which neither of those could have come from the defense, and they were more substantive than what's alleged against the defense attorneys. So there's others of those that Mr. McClellan knew about and could have directed investigations, and we'd like to know why not. Because I intend to show that this is a targeted prosecution for criminal contempt. So I think he should recuse himself, because he was also intimately involved in the investigation. For instance, when Sergeant Holman was interviewing Mr. Fortson, he told Mr. Fortson he was going to call the judge, and ended up calling Mr. McClellan, and then reported back to Mr. Fortson some additional threats about jail and contempt and obstruction of justice. So that's a conversation that was during the investigation, connected to the investigation. So I believe that he is a legitimate witness on that basis. And there's other involvement in the investigation and other knowledge of other leaks. And then we believe that the prosecution is going to allege that Mr. Westerman took 9 photographs without permission in the conference room of Mr. Baldwin's law office. But we don't believe that all 9 of those were taken by Mr. Westerman. And we will have evidence as to why they could not have been. If I remember correctly, that is about, because I think it was about crime scene photos where in the state's pictures, there were squares to censor areas. The defense used circles. So it's that's the difference. And the leak of certain photos had the wrong type of censorship markings, censor marks, if I remember correctly. You guys, if I'm out of bounds, I know you're going to tell me. I know you're going to tell me. Yeah, there were a couple of photos the defense had never seen before. Yeah. Yep, Mike's headphones, the shapes, colors of the blurs. Yep, so I remember correctly. I mean, this case, there was so much shadiness from the prosecution in this case that they overlap. There are too many to remember. Too many. Hey, Jay Cornish is here. Good to have you here. Good to have you here. All right. And we will have evidence as to why they could not have been. So that's why I think that Mr. McClellan should recuse himself from the contempt. As you can see, there are two other lawyers from the prosecution here today, one with more experience than Mr. McClellan, and they could easily handle the proceedings. Thank you, the court. Mr. McClellan. Why is she asking Mr. McClellan? This is when he should, the other lawyers should speak on his behalf. But he's speaking in his own interest, which is bad conduct. Mr. McClellan, Judge, a couple of different objections to make to Mr. Hennessy's motion. I tried to take them in order that he recited them to the court. In regards to the communication with Gary Baudet and then other leaks that the defense believed occurred in this case, I'm not sure how that evidence is relevant to what we're here to do today, Judge. In the state's mind, we're here for a very narrow focus, and that is to present evidence that supports the information in the state's filing of contemptuous information. I'm not sure how communication between I and another person and then other leaks the defense believe occurred have to do with anything with the allegations outlined in our information against Mr. Rozzi and Mr. Baldwin. And so I don't think that information is relevant or even pertinent for the court to hear in support or in denial of our information. Of course you don't. Of course you don't. Because that would... This is about the defense trying to make sure that the court knows this is what you allege against Baldwin and Rozzi. But then you also have to take into account what the state did. Because if what they did constitutes a disqualification, then Mr. McClellan should be disbarred. Again, Rule 401 says for it to be relevant, there has to be a tendency to make a fact more or less probable than it would be without the evidence. That's not the case here. The defense seems to want to say that, hey, we leaked information, but it's okay because the state leaked information. That is, in their mind, more important. And I just don't see how that's relevant. So that's the first argument in regards to Baudet and the leaks. If the court does find that it's relevant, again, the rules seem pretty clear that only in extraordinary circumstances can an opponent be called as a witness. If the court takes a look at Chapman v. State and Metheny v. State, those are both still good cases, and they say that the general rule is that counsel is not subject to being called as a witness unless it's required by a compelling and legitimate need. Those two cases, I believe, is about defense attorneys, not prosecutors. Where the evidence is easily available from other sources, you are the only one who talked to that guy. So you are the source. And absent extraordinary circumstances, an attorney who participates in a case should not be called as a witness. And again, that's under Metheny. Judge, here, if that evidence is relevant and the court does allow it in, they're able to get that through other means. They could call Gary Baudet. Yeah, but you need both sides. They could call all the people that they believed are involved in the leaks. It isn't necessary for me to testify on those matters, Judge. That is best evidence. Best evidence. In terms of the Westerman photos and how many photos were taken by Westerman, again, they can have Mitch Westerman here to testify to how many photos he took. And so that information is easily accessible through other witnesses. The state believes this is an attempt by the defense to derail the hearing today, knowing that I'm the one that's prepared for the hearing on the contemptuous information judge, and the other two prosecutors seated at this table haven't prepared for that. Don't care. The state is the state is the state is the state. Meaning, you're all one and the same in the eyes of the law. And so I think it's an effort by them to derail this hearing, and I would ask the court to deny the motion. The court, anything further? Mr. Hennessy, thank you, Judge. This is clearly an information for indirect criminal contempt. The law in that respect gives the accused, the defense attorneys, all the rights of any citizen accused of a crime, including to the right to present evidence, including representation. With regard to the relevancy, Judge, since it's an indirect criminal contempt proceeding, there are two issues. One, is there contempt? Two, if the court finds contempt, what is an appropriate punishment? The fact that, and Mr. McClellan, misspoke. They didn't release anything, not once. They didn't post anything publicly. It requires public dissemination. And so that accusation is false. And then he accuses me of having ulterior motives, which is also false and not appreciated. But on those two issues, whether they're in contempt or not, is other leaks are relevant and probative on that issue, because it requires willful conduct. Now, all the other leaks were purposeful. The people that posted it and leaked it, and keep in mind, it was more substantial information than what they're accusing them of, their attorneys of, that was willful. So that's a perspective. With regard to punishment, the fact that two probable cause affidavits leaked had details of the investigation. The alleged crime scene photos that were stolen by Mr. Westman those crime scene photos were going to be in evidence eventually. There's just no way around it. The probable cause affidavits, no. And they had more details. They had specific details. They posted information about the bullet and the gun found in Mr. Allen's house. That was not from the defense. And that was far more damaging in terms of leaks. So that's why it's relevant. With regarding to having Mr. Westerman here, I also wanted to ask Mr. McClellan what he did to get Mr. Westerman here, because he listed him as a witness, scheduled a deposition. He didn't show up. And with Gary Baudet, we can't get him here. And wanted. That's another reason when I'm going to renew my motion for continuous, but since he says no, since I can't get other people to say what his communications were, he shouldn't have to testify. He's kind of trying to shift the burden. So if the court's going to buy that, then I need time to do what he wants me to do. And we'll have to ask the court for some money to do that. So he's here. It's not my fault that nobody else got prepared for the hearing, because he's known for weeks. I told him early on, when I got on the contempt proceedings, I intended to do that, and I've never changed that position. Yeah. He got Mr. McClellan forewarned, I'm going to try to get you as a witness. And what does the state do? They make sure that only Mr. McClellan is prepared. That's intent. That's contempt. With regard to, and the other things in the clean hands doctrine, I think gives us relevancy with regard to his testifying. And then get Westerman here. What else did he say? Oh, also another thing that he would. We would want him to testify to is, after the court issued the gag order, there was an in-chambers off-record conference with the attorneys, and he participated in it. And basically, that was modified informally to allow the defense to share some information with regard to strategizing and preparing for trial. And he was present for that. And I believe we'll have testimony that he didn't object. And so that's another reason he should testify. So for all of those reasons, it is relevant. The other leaks are relevant, surely there's more than what I've laid out for the court here, which will be, there's evidence as we go through the hearing. The court, well, while I'm not conceding that anything from outside sources is relevant, if it may be relevant, then I suppose, but I see no compelling reason to have Mr. McClellan call as a witness to testify and deny your verified petition. Boom. No citing of law, no nothing, just denied. Mr. McLeland, are you ready to proceed on your information for contempt? Mr. Hennessy, I'm sorry. The court, I'm speaking with Mr. McLeland. Oh, I didn't know. Mr. McLeland, yes, Your Honor. The court, do you wish to make any preliminary statement or just get right into it? Mr. Hennessy, Your Honor, testimony. If I may, I have some preliminary matters I would like to address. The court, please don't interrupt me. I'm not done speaking with Mr. McLeland. Did you wish to make any preliminary statement or just go right into the evidence? Judge, I prefer just to get right into the evidence. I think my information outlines what we intend to present here today, Judge. The court, Mr. Hennessy, I have some additionally preliminary matters, if I may. The court, sure. Thank you. First, I would like to supplement Mr. Ausbrook's filings, which I'd like to have marked as Exhibit A, if I may approach the court reporter. The court, you may. May I? I'm sorry, I said you may. Thank you. Mr. Hennessy, says Mr. McLeland. Yes, sir? Oh, thank you. So, Judge, Defendant's Exhibit A is a publication, a bench note from the Indiana Supreme Court that was updated on January 1st, 2024, that lays out the procedure for the various types of contempt proceedings, if I may approach. Defendant's Exhibit A offered. The court, is there any objection to Defendant's A? McLeland, I don't have any objection. Show Defendant's A is admitted without objection. Defendant's Exhibit A admitted. Mr. Hennessy, do I give it to her or you? The court, to the court reporter, please. Hennessy, thank you. And then I would like to renew my continuance. Boom, 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 boom. Mr. Hennessy is doing his best, but he's up against a judge who doesn't care about the law. This is Jessica. So Westerman did take photos of the crime scene photos in the war room. However, the crime scene photos that went around were different from the crime scene photos taken by Westerman. Some of it were. Some of it were, to my knowledge. Good questions here. Good questions. Now, I'm going to be fully focused here. So if you have questions, you know these big red question marks, put that before or after. That way, I can easily see it. Hello, Rambo. Rambo Bambo. Let's continue. As the court knows, in my verified supplement, in my verified original motion, the discovery that I was receiving from the state was delayed. And I'm not alleging that. I'm not alleging anything improper in that regard. It just affects the way I've been able to do. For instance, the original Indiana State Police report regarding their leak investigation did not have the attachment because somebody clicked on the wrong button. which we discovered that, both Mr. McLeland and I, on March 1st. And then I didn't get them until because of some kind of e-discovery glitch. Yeah, it's weird. Everything that is supposed to be handed to the defense either never gets handed over or it gets delayed. No, Brandon, you cannot purchase organs in Sweden. We don't have that. I wouldn't. After Friday, I would need a new liver. And it went from pages 33 to pages 272. And so I was only able to go through that late last week. And there's a lot in there that I would want to follow up investigation on, and I need more time to do it. Mr. Mullins recording Mr. Woodhouse's YouTube, and with regard to Mr. Woodhouse, from the framing of the pleadings on the contempt proceedings, I would seem to be the accidentally misdirected email, which only had an attachment of an outline organizing discovery. And then I've not had time to watch the entire YouTube presentation of Mr. Woodhouse, but it appears that he also had photographs, which could not have come from the defense. And there was no connection between him, Mr. Westerman, Mr. Fortsum, Mr. Cohen, or anybody else that claims to have received them. I got recorded interviews taken by Sergeant Holman late. I've listened to them, I've taken notes, but I didn't have time to get them transcribed, which would simply make the ability to use them to cross-examine any witnesses more difficult, but not impossible. Mr. Snay contacted me within the last 3 or 4 days and shared information that he had about other leaks, which I would need to investigate and try to track down. We received additional screenshots from unknown people, and I need time to investigate that. I guess that's from a lot of you guys who sent them to him. Also, just in terms of adequate organization and making exhibits for presentation in an adversarial hearing, I need more time. So according to, well, I cited the case in my motions and I identified for the court that I need more time to do so. So I knew the request for, they're entitled to adequate representation. As I indicated, it's indirect contempt. All the rights and privileges of any citizen accused of a crime are present, and that includes the time necessary for adequate representation. Thank you. The court, Mr. McClelland. Judge, I'll try to take these in order again. I tried to jot them down. In terms of the ISP report, it was made available that Friday. Mr. Hennessy didn't want to drive to Delphi to get it, and so we attempted to deliver it through e-discovery. We attempted 3 times, and then he got it on Tuesday. I can't explain why you got it on Tuesday and not that Friday. Of course you can't. But that is true that we tried it. We did on e-discovery only because he didn't want to drive up to Delphi to get it in physical form. Oh no, Mr. Hennessy didn't want to drive 3 hours, well, an hour and a half there and then an hour and a half back because you can't fix your fucking e-discovery? Mullin's recording of the YouTube channel. My information is that he got that. He's had time to examine that. The recordings from Holman, they're not transcribed. I don't know that matters, Judge. We can still question Holman about those today. If he got notes on those, then he would be ready to go forward on those. The other leaks, again, Judge, I'm not sure how those are relevant to today's hearing. We are talking about the information the state filed with the court and not about other leaks. So I'm not sure that's relevant. And then the screenshots, I'm not sure which ones he's talking about. He did provide me with some screenshots. If there's the same ones he provided with me, again, I'm not sure how they're relevant, Judge, to today's hearing. So the state would ask the court deny the motion. The court, anything else? Mr. Hennessy, well, I appreciate Mr. McLean believing that I should be ready, but I'm not, and that's the key. And the key is if I provide the court with specific reasons, and I've done that, and it's just a matter of fairness and justice. Thank you. The court, all right. The supplemental motion for continuance is also denied. Anything else? Just rubber stamps denies. Mr. Hennessy, and then thank you, Judge. I would like to, well, I'll take that up at another time. I've also had filed there. Oh, wait, Your Honor, I need to interpose an objection to the lack of a special judge. It's clear that the information for contemptuous conduct was filed pursuant to 344735. 344737 provides that indirect contempt requires a special judge for any part of the allegations that are not alleged to be in violation of a direct order of the court. So they've alleged the press release, which was a day before the order, so it cannot be directly connected to an order of the court. They allege a failure, and if there was some obligation to notify the prosecution and the court that there was a misdirected email that was accidental and that Mr. Baldwin followed up on with the wrong recipient within the hour, asked him to delete it, so he had every reason to believe it was clear. But there's no direct order of the court that applies to accidentally misdirected emails. The conversation that they got out of Westerman's iCloud account, that's not a direct order. The failure to secure evidence and discovery materials, there was no order from the court that they secure any such materials. Not being completely honest with the court, that involves, 1, it's false, but 2, that involves evidence away apart from. So for all, what 344737C says is that for all items not related to a court order, including any claim of contempt based on acts cumulatively taken, a special judge has to be appointed under IC 344737C. And that's also in the bench note that was issued by the Indiana Supreme Court. So I request a ruling on my objection for the lack of a special judge for the contempt proceedings. The court, Mr. McClelland. Mr. McClelland, Judge, I think the court takes a look at Section B under that Indiana code. It states, quote, This section does not apply to an indirect contempt growing out of willfully resisting, hindering, delaying, or disobeying any lawful process or order of the court, end quote. So I think that allows this court to proceed over the information that the state has filed. Hate to admit it, but yeah. It's under the court. It seems to be under the court's discretion. Now, in objectively, she should have appointed a special judge for that part. Just for the appearance of being unbiased, because she already lost in the Indiana Supreme Court regarding disqualifying these people. So her doing the contempt hearing, she shouldn't have. But here we are. The court, and I would find that the February 17th, 2023 order that was issued at the state request for a protective order governing discovery is an actual order. Mr. Hennessy, your objection is noted. Mr. Hennessy, and then I'd like to, you're not ruled on it yet, but I did file for a judicial recusal, and I would like to have marked and admitted into evidence your email from October 8th, 2023, and your, as Exhibit B, and then your email of May 2nd, 2023, as Exhibit C, if I can approach the court reporter. Defendants Exhibit B and C offered. The court, you may. When was that filed? Mr. Hennessy, I'm sorry. The court, when was that filed? Mr. Hennessy, oh, the recusal petition? The court, yes. I'll have to look. Mr. McClelland, Judge, it was filed the same time all the other motions was filed. The court, March 12th. Mr. McClelland, the motion to recuse. The court, okay, I found it. Mr. McClelland, should have been all filed at the same date. Mr. Hennessy, thank you. The court, is there any objection to whatever it is? Mr. McClelland, no, Judge, sorry. I didn't know the court was waiting on me. I apologize. The court, no, it's okay. I don't know what your exhibits are, sir. Mr. Hennessy, may I approach? The court, have they been marked? Mr. Hennessy, yes. The court, okay, what are they? Mr. Hennessy, it's your email from October 8th, 2023, and what is the exhibit number, sir? B is the October 8th, 2023, and C is the May 2nd, 2023. The court, all right, I'll show without objection, B and C are admitted. Defendants Exhibit B and C admitted. Mr. Hennessy, and then with regard to the judicial recusal, I would like to call Sergeant Holman for some brief testimony. If you'd like me to sum it up, I would. Why don't you just sum it up? Mr. Hennessy, I'm sorry. The court, sum it up. Mr. Hennessy, okay. When he interviewed people, he invoked the power of the court, and he would tell them that the judge is very adamant that they delete the photos or give them to him. He indicated that you would issue contempt of court, and with Mr. Fortsum, he said he could call you, reach you immediately, and see if you wanted to issue that order of contempt. So what he put in the minds of other citizens was that the court was deeply involved in the investigation, ready at a moment's notice to send them to jail. And I would like to have his testimony on the record in support of the judicial recusal, so it's in the record. Folks, Holman is, I believe, clinically a moron, but he is a dangerous one, a really, really dangerous one, because once he gets it in his mind that he can do something, he does it, regardless of the law, because he's too stupid to understand better. And that is probably his defense into all of this. And yet, he's been a cop for what, 20 years? A sergeant at this time? Fat pig fuck. I can say that because I'm fat myself. Now, I'm properly fat, not this slobbery fat. Now, I don't want to say that. I have friends with the same kind of fatness as him. So, he's just clinically a moron. The court, is that an offer to prove? Mr. Hennessy, well, no, I want to call him to testify. The court, an objection, Mr. McClelland. Why do you ask him if there is an objection? If he wants to object, he can say it himself. Mr. McLean, Judge, again, let me address exhibits B and C. I don't think that those exhibits show any bias on the court's part. I'm familiar with those emails, and again, don't show any prejudging by the court or any bias towards anyone involved in this hearing. In regards to the testimony of Sergeant Tolman, I guess I'm not sure how his statements show that the court is not appropriate to preside over these matters. And so again, I don't think it's relevant in terms of this motion for recusal, Judge, and so the state would object to that. The court, well, in your motion, sir, in paragraph 10, you indicate that the court conducted its own investigation. I did no such thing. Liar. I directed counsel to cooperate. I directed counsel to get to the bottom of what was going on. That's not your job. Your request for your recusal is denied. She really quickly got into denied because she didn't want more on the record. Mr. Hennessy and the court, did you have any other preliminary matters before we get to? Mr. Hennessy, I'm looking because you made some rulings just here today. I need to take off my list. No, ma'am. Mr. Hennessy, I would do a brief opening statement if the court would allow. The court, go ahead. Hennessy is really smart here because he knows that if he gives Dov the chance, she will get everything to the prosecution and nothing to the defense. So he is boom, boom, boom. He knows what he's doing here. Mr. Hennessy, thank you. As I pointed out, Judge, there are two issues. One, whether there is contempt, and two, what an appropriate punishment would be if the court does find contempt. With regard to the contempt, the information, it is not properly filed. The information should have been filed in a separate action. It fails to give adequate notice on what exactly they are alleging was contemptuous conduct. What I can glean from the filing is that the press release of December 1st, and there was no order prohibiting that until December 2nd. And then they say that misdirected email. That was not willful. There was no duty or obligation to report it. And when it was discovered that Mr. Woodhouse has been dishonest about deleting it, both Mr. Baldwin and Mr. Rozzi were open, honest, and completely cooperative. And then, as I indicated earlier, the prospective, the alleged leak, and this leak, and then so I don't know what else they're alleging. Oh, Westerman. But they charge him with conversion. So if somebody breaks, and they're apparently saying that violated one of the court's orders, but it has to be willful. If somebody breaks into my house and steals embarrassing photographs and then puts them on the internet, that's not my fault. I didn't publicly disseminate any embarrassing photographs. And that's exactly what the allegation regarding Mr. Westerman is. They admit that they were taken without authorization. Both Mr. Baldwin and Mr. Rozzi cooperated in the investigation. So the facts and the law, after all the evidence, there is should not be any finding of contempt. Thank you. The court, did you wish to make any statement, Mr. McLeland? Mr. Hennessy, I'm sorry? Mr. McLeland, Judge, again, I think the information and testimony we have today will speak for itself. I think I've outlined in my information that from the evidence the state gathered, we believe it's more than just Westerman breaking into the office of Mr. Baldwin. From the evidence we gathered, it looks like it was a continuous and ongoing leak up until the leaked crime scene photos. And so again, all this is outlined in the information. Judge, I don't think it's necessary to regurgitate all of it to the court here today. And so the state's ready to go forward with evidence, Judge, and jump right into it. The court, you may call your first witness. Mr. McLean, Judge, before I call my first witness, I would ask the court to take judicial notice on the Rule 2.1 of the gag order that was filed by the state, November 22nd, 2022 in this case, and then the court's order granting that gag order on December 1st of 2022. And then I'd also ask the court to take judicial notice with what I'm going to have marked as State Exhibit 1, which is the press release released from the defense on December 1st, 2022, Judge. State's Exhibit 1 offered, the court. All right. I will take the judicial notice of the motion filed by the state of Indiana for an order prohibiting parties, counsel, law enforcement, etc. The gag order that was filed on November 22nd of 2022. I would also take judicial notice of the order that this court entered on December 1st of 2022, granting the state's motion for a gag order. But it wasn't published until the day after. And State's Exhibit 1 is the press release that was issued by the defendant counsel. Any objection? Mr. Hennessy, well, first I object to judicial notice, and I'm looking for it. Both Mr. McLeland and the court indicated it was issued December 1st, 2022. Correct. And the chronological case summary says December 2nd. And I'm trying to find the gag order because I reviewed it a number of times, and I believe it was file marked December 2nd, 2022. But I would like to clarify that. So I would object on relevancy on State's Exhibit 1. What was it? The press release. I would object on relevancy because of the respective dates. The court. All right. I show that the court granted the defendants or the state's motion on December 2nd. I will take judicial notice of that order December 2nd, 2022. On December 1st, I set that for hearing. Mr. Hennessy, so it is December 2nd, correct? The court, correct. Yeah, she can't lie about that. Mr. Hennessy, well then, therefore I object on relevancy. Because the press release was dated December 1st, 2022, so that order cannot be relevant to something that was done the day before. The court, so you're objecting to State's Exhibit 1. Mr. Hennessy, that's my objection to State's 1, and it's also my objection to the court taking judicial notice. 1 under 2.1, it says you can take judicial notice if provided accurate information. And you were not provided accurate information because he said it was December 1st, 2022. And the court accepted that assessment until reviewed at my request. So it don't fit 2. It does not fit 2.1. Mr. McLeland? Judge, under 2.1, the court can take judicial notice of a fact that is not subject to reasonable dispute because it's generally known within the trial court's territorial jurisdiction, and it can accurately and readily be determined from sources whose accuracy cannot reasonably be questioned. In terms of the 2 orders, those are part of the CCS, Judge. Mr. Hennessy is right. I misspoke. Oh, no, you didn't. You lied. It looks like it was ordered on December 2nd, and so the motion was filed on November 22nd. It was ordered in December 2nd, so I think it's pretty clear that the court can take judicial notice of those because those are not disputed. But it's not relevant to the press release because the press release was released before the order. So I think it's pretty clear the court can take judicial notice of those because they are not disputed. In terms of the press release, Judge, again, I don't think it's something that's disputed. Mr. Hennessy brought up it several times in his opening arguments and motions or remarks to his motion that he's filed. So there's no dispute that this was filed or that press release is from the defense. And again, I think the court even says in their order for the gag order that on the court's motion, in response to defendant's undated press release, it doesn't matter what the court says. If it has a date on it, it's dated. And so I think it's relevant because that it looks like that prompted the court to issue the gag order without a hearing. So I think in that case, the gag order is wrongfully ordered. If it was based fuck that. Again, I think the court's well aware of it. I think that's why the court made the order for the gag order. So I think the court can take judicial notice of it under 2.1. Mr. Hennessy, may I? The court, sure. Mr. Hennessy, thank you. The issue here, as it says, is contempt. So there would have to be evidence of a violation of a court order, which it cannot be. It just can't. It's the day before. Now, I understand, based on discussions in chambers, some people might be disconcerted by it. But it wasn't a violation of a court order, so it's not relevant to his allegations of contempt. The court, I will show State's Exhibit 1 is admitted over objection. Of course she does. As the objection goes to the weight that the court would give that particular exhibit rather than its admissibility. Is there anything else before we get into the actual evidence? Mr. Hennessy, are you taking judicial notice? The court, yes, I'm taking judicial notice of the court's record dated December 2nd, 2022. Mr. Hennessy, over the defense objection? The court, yes, sir. Mr. Hennessy, thank you. Judge, the state's prepared to call its first witness. The court, you may call your first witness. Direct examination of Stephen Mullin. Now again, the interviews within the hearings, I will cut out to separate videos. That way it will be easier to find for everybody involved. Now, this stream is also dated, but it will also be released as separate videos. I know that those videos get very few views because it's not even though I wish they would be, it's not. It's just for the purpose of being easily found. Direct examination of Stephen Mullin. Mr. McLeland, Judge, the state would call investigator Steve Mullins. Oh, another guy that at the same time that Judge Gull enters the depths of hell, so will Mr. Mullin. Question by Mr. McLeland. Will you state your name, please? Stephen L. Mullin. And where are you employed? At the Carroll County Prosecutor's Office as investigator. And how long have you been employed in that capacity? Since January of 2020. Don said, yeah, Hennessy is really good at letting the judge dig her own hole. Yeah. He refuses. Mr. Hennessy is refusing to allow Judge Gull to just skim things over. Because he knows what an absolute shithead she is. And prior to that employment, were you employed in law enforcement capacity? Yes, I was. Can you tell me about that, please? I was a police officer with the Delphi Police Department, and then a deputy sheriff at the Carroll County Sheriff's Department, detective at the Carroll County Sheriff's Department, chief of police in Delphi, and then at the Carroll County Prosecutor's Office as an investigator. So this piece of human garbage, a lies in human form, was directly involved in the interviews, or should I say, in my opinion, the deletion of 70 days of initial interviews. That in itself, folks, the deletion, whether it's intentional or not, I believe it was absolutely intentional, should have made this case go away. Because it made it impossible for the defense to cross-examine certain witnesses, to even call certain witnesses. I believe it was but here's the thing. Since they couldn't prove it was intentional, and the cops involved said, oh, whoopsie. And with Judge Gull, yeah. Jesus Christ, I hate this. How long have you been a law enforcement officer, if you know? 42 years. So for 42 years, he is collecting taxpayers' money, doing shit as an investigator. Okay, as part of your duties with the investigator, with being an investigator in the Carroll County Prosecutor's Office, are you working on the case of the state of Indiana versus Rick Allen? Yes, I am. And tell me largely what your role has been in that case up to date. Hennessy, objection, relevancy, we're here for contempt. This investigation regarding the issues raised by the prosecution's information is what is relevant. The court overruled. Mr. Hennessy, not in investigations of the court overruled. Judge, I'll rephrase the question. I'm okay with staying away from that. Yeah. Question. So I want to move on, Mr. or Investigator Mullins. Are you familiar with an individual with the name of Brandon Woodhouse? Yes, I am. And how are you familiar with him? Brandon Woodhouse has been arrested in Carroll County for various law offenses over the years. And so it's fair to say he has a lengthy history, criminal history in Carroll County. Yes, it does. Now, Mr. Woodhouse came on your radar more recently in March of 2023. Is that correct? Yes. How did he come on your radar during that time? I received a phone call from a person who identified herself as Dorina Hipscher. She informed me there was a YouTube channel that Brandon had created. And did you go and view that YouTube channel? I did. And what did you see on the YouTube channel? On the YouTube channel, I observed that Brandon Woodhouse had a screenshot of the listed evidence in the Richard Allen case. And you were familiar with that list of evidence? Yes, I was. Have you viewed the evidence or the discovery involved in the Richard Allen case? Yes, I have. And is it safe to say you're familiar with that evidence? Yes, I am. I'm going to show you what's being marked as State's Exhibit B, I believe. Mr. Hennessy, State's Exhibit what? Mr. McLean, 2. I'm sorry, Judge. I misspoke. State's Exhibit 2. Investigator Mullin, can you describe that document? Yes, it's the same as I saw on Brandon Woodhouse's YouTube page. It's titled Richard Allen Thumb Drive Map. And what was the title of the document that you saw on Brandon Woodhouse's YouTube page? Yes, it was. And tell me, you told me the title. What does the document contain? It contains information concerning the Richard Allen case, witnesses and evidence for the case. And does that match what is on the YouTube channel for Brandon Woodhouse? Yes, it does. Mr. McLean, Judge, the state would move to admit what has been marked as Exhibit 2 into evidence. Mr. Hennessy, no objection. The court, all right, without objection, 2 is admitted. Folks, I need to get myself something to drink because my throat is drying up a bit. I'll be back in a couple of seconds. Thanks for waiting. Oh. Yes, of course I have skull-shaped glasses. If I could have merch in the shape of skull, I would, but I don't have that option. Ah. Okay, I see there's a discussion regarding Andrea. Andrea is still covering this case. I talked to her, and once we get to the actual trial, she will be here as one of the voices to help. At least, yeah, she would help with the reading of the actual trial. Well, when we come to trial, she will be here at some point, at least. That is the latest I've heard from her. And yes, she has offered her help to the appeals attorneys, but it appears that the appeals attorneys doesn't require any assistance, at least. She's still passionate about Rick's case. But since we are all in the waiting game, she covers other cases. I cover other cases as well. Now, I have the time for this because I make the time for this. She has less time. So she does it by finding other cases that she's equally passionate about. So please know, she does what she can. If I have questions for her, she will always answer, and that is good. She's doing good. All right, let's continue. As your role as of the investigator, you've also been tasked by me to assist in the exchange in discovery with the defense for the Rickard Allen case. Is that true? Yes. The person who fucked up the 70 days of interviews is the same person tasked to hand over discovery to the defense. Isn't that really fucking strange? How would you make it as easy as possible to hide things from the defense? Well, by tasking the person who has hid things before. I mean, it's so clear. This was why he was tasked with exchanging discovery. Because he knew how to hide it. Yes. And tell me the normal procedure that you go through when you're exchanging discovery with the defense. My practice was to create an itemized list of the items that were to be given over to the defense, whether they be information files or whatever they were, and then have the defense and agent sign for the release of those items. And so you would draft a receipt or a list of items you were handing over to the defense, and then have that for the defense to sign once those items was picked up. Is that correct? Yes. I'm going to show you what's been marked as State Exhibit 3. Can you describe that document that I handed you? Yes. It's a receipt which I drafted for a release of evidence. I titled it 1-0 or 10 Allen. And can you outline the evidence, or is that a document you drafted? Yes, it is. And does it have both Attorney Rozzi's and Attorney Baldwin's name on it? Yes, it does. And did that document describe evidence that you turned over to them as part of discovery? Yes, it was. And again, that's a document you drafted? Yes, it is. Judge, the state would move to admit what's been marked as State Exhibit 3. Mr. Hennessy, objection. It's never been provided to me in discovery regarding the contempt proceedings. I asked to enlarge the discovery deadline, and the court denied it. And I object because it's never been provided to me before, and it's not been connected to the thumb drive map, and therefore it's not relevant. Court, any response? Yes, Judge. If the court would just give me a moment, I'm going to pull up the date of that email that I sent Mr. Hennessy that had that attachment in it. In terms of relevancy, Judge, I believe it's relevant for information that's going to appear later in the hearing in terms of a continued leak by defense of information. Judge, I apologize. I'm having trouble. I sent all the attachment, all the exhibits in an email. Judge, I'm trying to get the court a date for that email and confirm that Mr. Hennessy received it. Judge, I apologize. I can't seem to find the email at my fingertips here that I sent Mr. Hennessy. But it was included in an email with other attachment that I sent to Mr. Hennessy as part of discovery from the contempt. Mr. Hennessy, can I? The court, no, he's still looking. I guess I'm not sure what the objection is. That you didn't get it? Your client certainly got it if they signed for it. Mr. Hennessy, I didn't get it. What you ordered was to exchange the exhibit for the contempt hearing. The court, yes. Mr. Hennessy, even if they had it, it was never identified to me for potential use in the contempt hearing. That's the kind of notice that the reciprocal discovery requires. And I will also note that the items that are listed in State Exhibit 3 are not on State Exhibit 2. And so 2 was admitted without objection because it was the attachment that was accidentally sent to Mr. Woodhouse. So since the item listed on 3 aren't on 2, it's not admitted. It's not relevant. The court, I'll show 3 is not admitted. I'm sorry. I will show 3 is not admitted. Mr. Hennessy, thank you. I'm sorry, but the court, do you need an assisted listening device? Oh, you garbage human being. Mr. Hennessy, I'm sorry. Oh, no, I just tried to. The court, go ahead. Mr. McLellan, thank you, Judge. And so, Mr. Mullin, or Investigator Mussel, yeah, it was never sent. I know. Mr. McLellan is trying to get away with everything. And he lies to the court. He gets caught. And then, oh, but that's just a mistake. Just a mistake. And so, Mr. Mullin or Investigator Mullins, is your practice again to draft a receipt for the defense for when they picked up discovery? Yes. Okay. And you would list out the discovery in that receipt. You would list the discovery that you were turning over to them. Yes, I would. And then you would have somebody, a representative from their office or them themselves, sign for the discovery and date when they receive that discovery. Is that correct? Yes, that is correct. And what was your common practice for all items that you turned over as part of discovery? Correct. Yes, it was. Okay, do you recall, as part of discovery that you handed over to defense, do you recall there being an interview with a professor from Purdue with the name of Jeffrey Turco? Oh, the Purdue professor, which the state and the investigator said, we don't remember the name, and we don't think we will ever find out the name. And then the defense says, oh, well, here it is. So all of a sudden, it was really easy, because what the prosecution said to the court, or in a motion at least, is that this professor said, no, there is no connection to Odinism found on the crime scene, which was a lie. This Purdue professor said later in an affidavit that it can be. So they lied to the court, but they are allowed to, because Judge Gall allows them to lie to the court if it suits her. Yes. And what kind of was it an audio video interview, or what kind of interview was that? I believe it was an audio interview of Professor Turco that I handed over to the defense. And would you have gone through the same procedure when you handed over that evidence to the defense of making a receipt and documenting that in the receipt, meaning when I say that, meaning what discovery you're handing over to them? Yes, I would. And would you have had the representative from their office date it when they picked it up? Yes. Do you recall from your memory when the defense picked up the information concerning the interview with Professor Turco? I believe it was September the 27th. I don't have the document in front of me. After. Or in connection. Oh, I mean, the Franks motion was submitted in September of 2023. And by now we found it. The thing that we said never existed. All of a sudden they found it in view and handed it over. Because they were caught lying. And what did Judge Gall do about lying from the prosecution? Nothing. Okay, yes. So you believe they picked up that information on September 27th of 2023? Yes, September 27th. Mr. McLeland, I don't have any other questions, Judge. The court, Mr. Hennessy. Thank you, Judge. Cross-examination of Stephen Mullin. Question by Mr. Hennessy. Question, you first learned about the Brandon Woodhouse YouTube from Miss Hipsher. Yes, I was. And what she told you was that Brandon Woodhouse actually had Rick Allen's thumb drive, didn't she? Something to that effect, yes. And was that not true? No. And on the YouTube, you saw the map of the thumb drive, correct. And that simply identified what was on that thumb drive. Can you repeat the question, please? Sure. The map simply identified what was on that particular thumb drive. I'm sorry, I'm not sure I understand what you're trying to say. Yeah, it's the brain worm exists in Delphi as well. I'll move on. Do you organize discovery for the prosecutor? Yes. Do you make a list that's handy for him and his assistants to locate any particular piece of discovery? I create an itemized list of the items that we have as I go along, yes. So that would be like a map for them to go find the actual piece of evidence. I have done something like that, yes. And that is exactly what you saw on the YouTube, only it was for the defense, correct? What I saw on the YouTube channel was what I said earlier, and the picture shows what that was. At the title at the top of the page, it said Richard Allen thumb drive map. But it did not have any substance of what anyone said, correct? It showed a list of the items and witnesses. Correct. But it didn't say what the witnesses had said. Correct. So there was no substance to it. In that sense, yes. And then did you see anything else on YouTube? Mr. Woodhouse was simply talking about the items on the list of items that were on the thumb drive, or what he called the thumb drive. Did he show any pictures? No. And then, did you ever contact Mr. Woodhouse? I did not. Did you interview anybody else regarding the Woodhouse document? Other than Mrs. Hipsher? No. And you saw the actual email that was accidentally sent to the wrong recipient, Mr. Woodhouse? I don't believe I did. So you don't know it was addressed to Brad and not Brandon? I don't know. Why did you not look at the actual email? I have enough to look at. I didn't have time to focus on any other issues other than this, and I handed my report over to the prosecutor. So you couldn't read a 4-line email, but you went through a multiple-page thumb drive map. I looked at what was on the YouTube channel and transmitted that to the prosecuting attorney. Right. But you just told me you didn't have time to read a 4-line email that said Brad and not Brandon. You just didn't have time, right? I'm not sure I understand your question. Okay. Well, I'm asking you if you have just said today under oath that you just didn't have time to review the 4-line email that was addressed to Brad and not Brandon. Yes. Okay, so you, as you sit here, have no knowledge whether Mr. Baldwin intended to email Brandon Woodhouse, correct? As I said, I only looked at what I had in front of me. Right. So you have no information or knowledge that Mr. Baldwin intended to email Brandon Woodhouse. I don't know what his intent was. I'm sorry. The question is, do you have any information, Mr. McClelland, which I'm going to object? He's asked and answered the question. He can speculate as to what Mr. Baldwin meant or did not mean to do. Mr. Hennessy, well then, Mr. McClelland's not understanding the question either. I'm not asking him to opine as to what Mr. Baldwin's intent was. I am asking him if he has any information or knowledge. He was assigned to investigate Brandon Woodhouse. The court, but that's not the question you asked him. You asked him what his intent was, and he said that was the objection. I would sustain the objection. Okay. Do you have any information or knowledge? Strike that. You were assigned by Mr. McClelland to investigate the Brandon Woodhouse information, correct? Mr. McClelland, Judge, I'm going to object again. That's not what Mr. Mullins testified to. Mr. Mullins testified he was contacted by Ms. Hipsher that Brandon Woodhouse had a YouTube channel and he viewed that YouTube channel. The court sustained. Question, size. So Jody is perfectly able to add in these kind, but she doesn't do it towards the prosecutor or the judge's eye rolls or the judge's size. After you spoke to Ms. Hipsher, did you report that to Mr. McClelland? I'm sorry, can you repeat the question? Sure. After you got the information from Ms. Hipsher, did you report that to Mr. McClelland? Yes, I did. And what did he tell you to do? Document it. And why did you then go watch the YouTube? I already watched the YouTube when I reported it to Mr. McClelland. Okay. And then do you have any information from anyone that Mr. Baldwin meant to send an email to Brandon Woodhouse? Again, I'm going to object. Mr. Hennessy, it's information, Judge. Does he have any information? The court overruled. Mr. Hennessy, that's a yes or no question. The court overruled. Do you have any information that Mr. Baldwin intended to email Brandon Woodhouse? I don't know what his intent was. That's not Mr. Hennessy. Can you direct him to answer the specific question, Judge? The court, did you have any information? Oh, no, I did not. Do you have any knowledge of such? No, thank you. I mean, this is a 10-minute back and forth because I'm reading it quite fast. But he is trying to avoid answering the question asked. And then you did no other investigation regarding Westerman's photos or any other leaks? No. In your employment with the Carroll County Prosecutor's Office, did you become aware of other leaks, other investigation of any other leaks? Mr. McLean, Judge, I'm going to object to relevance. That's not what we're here to discuss today, Judge. We, the state, has outlined the contemptuous information, and it's the state's belief that the investigation of other leaks and whether or not he's conducted those or looked into those isn't relevant to the information here today, Judge. The desperation here from Mr. McLeland, because I could bet money there are other leaks that Mr. Mullins looked at, but he found that it was from the prosecution, so he did nothing. Mr. Hennessy, I just only asked if he investigated anything else, and his answer, no, would have been a lot shorter than this discourse. The court sustained. Of course she does. And then, you remember giving a deposition on March 1st? Yep. Or 2024? Yes. And you were under oath? Yes. And do you recall saying that Mr. Woodhouse was displaying screenshots in his YouTube video? Yes. So you did see some screenshots in the YouTube video. I saw the display on his laptop showing what I've already described as the information contained in Richard Allen thumb drive map. And then you took screenshots. I did. That's all I have. Wait, Ms. McLean, that's all I've had. Mr. Hennessy, Ms. McLean, Judge, thank you. Redirect examination. So when in the deposition, when he said that Mr. Woodhouse was displaying screenshots, he didn't. Mr. Mullins took screenshots. Questions by Mr. McLeland. Investigator Mullen, the outline that you saw on Woodhouse's YouTube, is that something you created and then handed over to the defense as part of discovery? No. Okay. And so have you ever seen that document prior to viewing it on Mr. Woodhouse's YouTube channel? I had not. And so it's not something that someone else created that you turned over as part of discovery. Is that correct? I did not create that document. Okay. When you saw the YouTube channel, the information in the probable cause, meaning the witnesses' names, was that information sealed, do you know? I believe it was at the time. And so the outline listed several of the witnesses, including some juvenile witnesses. Is that correct? It did. I don't have any other questions, Judge. Mr. Hennessy. Recross examination. Question by Mr. Hennessy. What was the date of the email? I don't know what the date of the email was. I didn't. So I never saw an email. So you don't know if it was before or after anything was sealed or unsealed. That will be correct. Okay, and then, did you know that the affidavit with those names had been leaked by Gary Baudette before they were unsealed and before it was available to the defense? I don't know. Okay, nothing further. All right, thank you, sir. You may step down. Thank you. The court, you may call your next witness. Mr. McLean, before I do that, this has been done. The court already has this document from Mr. Hennessy's, I guess, preliminary motions, but I think it's important to resubmit it again in this context, since we're dealing with the contempt now. And so the state is going to ask the court to take judicial notice of what I'm going to mark as State Exhibit 4, which is the email from the court, and it's the email chain that Mr. Hennessy has previously admitted. State Exhibit 4 offered. Any objections? No. All right. Without objection, 4 is admitted. Mr. McLeland, and again, Judge, that shows them there's an explanation there from the defense of when the email was sent, and so that clears up the date when it was sent. To give to the court some context when it was sent, the court. Okay. McLeland, the state would next call Lieutenant Jerry Holman. Hold on here. Hold on here. I'm just going to show you something. Hold on. I'll be right back. I'll be right back. Yes. If I'm going to have Holman reading something from him, I'm going to act as Detective Holman's third cousin by inbred marriage, Arthur Holman. You may call me A Holman. Oh, I'm having way too much fun with that. Way too much fun with that. Witness Thorn. Direct examination of Lieutenant Jerry Holman. Question by Mr. McLellan. Will you state your name, please? Jerry Holman. Holeman. And how are you employed? With the Indiana State Police. And how long have you been employed in that capacity? It'll be 22 years in June. I have no idea how Holman sounds. And did you go through special training or education to become a law enforcement officer? Yes, I did. Can you tell me about that, please? I went through the Indiana State Police Academy. I graduated. I started January 2001 and graduated in June of 2001. And are you familiar with the state of Indiana versus Richard Allen? Yes, I am. Are you an investigator who participated in the investigation of that case? Yes, I am. I just got a pop-up that I'm offline. People, tell me if you can still hear me and see me. Okay. Yep. You're here. Yep. You're still here. Okay. I get that pop-up every now and then. Yep. You can hear and see me. Yeah. All right. Let's continue. And I want to take you back to October of the beginning of October of 2023. Do you recall that time? Yes, I do. And what happened in the beginning of October of 2023? I received a phone call from you stating that you had received information from Becky Patty, who is the grandmother and legal guardian of Liberty German, that crime scene photos were being leaked. And once you were told of that information, what did you do next? I started inquiring on what type of photos were leaked and tried to find out where they were being leaked from. And what did you do first to go about finding out that information? Well, I received a phone call from Ain Kane and Kevin Greenlee, who said they have also received the photos, and they described those photos to me over the phone. Well, when those photos were described to you, were you familiar with the photos they were talking about? Yes, I was. How were you familiar with those photos? One of the descriptions of the photos was one that Mr. Baldwin and Mr. Rozzi showed me in my deposition. And why was it unique enough that you could tell the photo from a description? It was a side-by-side that I never seen before that day, and it was created obviously by the defense attorneys. And I recall seeing it that day, and that's the only time I've ever saw that photo. And so from the description of those individuals you talked to, you recognized the photo was something the defense had created? Yes. What did you do next? I believe I called back to you to let you know that it was more than just what Betty Patty had told you. And from there, where did the investigation lead you? I talked to, again, Ain Kane and Kevin Greenlee, who said that they knew who sent them the photos. And who sent them the photos? Mr. Cohen. And did you speak to Mr. Cohen? Later, I did. Mr. Hennessy, objection, hearsay, violation of the right to confrontation. The court overruled. Did you speak to Mr. Cohen? I did later. But before that, I got information from Ain and Kevin. They said that Mr. Hold on, Mr. Hennessy, objection. What did he say? The court, did you stop him there? Mr. McLellan, yes. And when you spoke to Ain and Kevin, Did you get documents from them? Yes. What documents did you get from them? They gave me several documents that were screenshots that they received from Mr. Cohen with communication with Mr. Fortson. Okay. Did you receive any pictures from them? Yes. And what pictures did you receive from them? The pictures that they stated that Mr. Cohen sent them. And when you got the pictures from them, did you recognize the photos? Yes, I did. And I don't want you to go into detail, but what were the photos of? Some of them were of the crime scene that, again, I knew had to come from the defense attorney because one of them was of Liberty and her private part was blacked out and they used a circle. And in all the ones that we ever used for any type of reason, we used rectangles. I'm going to show you what's been marked as Defendant's Exhibit 5, State's Exhibit 5. Mr. Hennessy, yeah, there you go. Can you take a look at those documents, please? And can you tell the court what those documents are? The first one is a picture. No, just as a group. I'm sorry. Oh, it was a bad question. Can you tell the court as a group what those documents are? Photos are received from Kevin and Ain. And what do those photos show? Crime scene photos. Some of them are pictures of drawings of the crime scene. And do you recognize those photos? Yes, I do. And how do you recognize those photos? Again, they're crime scene photos and also photos that were presented to me in my deposition. Judge, I'm going to ask the court to admit what's been marked as State's Exhibit 5. I'm going to ask the court to admit those under seal. They are graphic crime scene photos. I did not transmit those to defense. I told Mr. Hennessy I was not going to transmit those to him. Mr. Hennessy, let's see them. Mr. McLennan, I'm more than happy to have them look at those, but I would like those filed under seal, Judge. The court under objection. Mr. Hennessy, Judge, yeah, I need to see them. Mr. McLennan, let me look at them. I never received copies because I didn't want to, because I don't want to be sitting accused of contempt. I have no reason to object to them being placed on the seal. The court, all right, I will show 5 is admitted without objection, and I will seal. No, I need to see the exhibit. You asked if I objected to them being sealed. I got to make sure that this is what I was shown before because they weren't given. The court, showing the photos, please. Mr. Hennessy, no objection, please. Judge. The court, all right, I'll show 5 is admitted without objection, and without objection, 5 will be sealed. Now, Mr. Holman, if you recall, were those all the photos that you received from Miss Kane? Sorry, the individuals, Kane and Ain? No. Okay, those are just the ones we admitted are just a portion of those. Yes. Okay, and again, the ones specifically of the crime scene depicting Liberty, was that something that law enforcement created? No. And how did you know that? Like I said earlier, we use rectangles to block out the private parts. And that one had one rectangle and a circle. So I knew it was not produced by any of us. When you saw that photo, did you recognize it though? Yes. Where did you recognize it from? It was a crime scene photo that was used and was taken from the scene. Was it also presented to you in a deposition? I believe so, yes. Same questions with the side-by-side photos that showed Abby. Did you? Is that something that law enforcement created? No. Did you recognize the photo? Yes. How did you recognize it? It was shown to me in the deposition by Mr. Baldwin and Mr. Rozzi. Once you got those photos, what did you do? Once you got the photos and the information from Kevin and Ain, what did you do from here? From there. I notified you again of the photos, and that was my thought there were, and then I scheduled a time to meet with Ain and Kevin to take a statement and receive all the information that they got from Mr. Cohen. And as part of the information, the documents that you got from them during that interview, did those include screenshots of messages? Yes. And who were the messages between? Mr. Cohen and Mr. Fortson. How did you know they were between Mr. Cohen and Mr. Fortson? Well, I saw the pictures of the Facebook pictures of Mr. Fortson and Mr. Coleman told me they were. So you were able to identify from the messages Mr. Fortson? Yes. I'm going to show you what's been marked at State's Exhibit 6, I believe. Are you familiar with that bundle of documents? Yes, I am. And how are you familiar with that bundle of documents? Those are documents that I received from Mr. Greenlee and Mrs. Kane. And can you describe what those documents are? Not the content of them, but what they are. There are screenshots of communications between Mr. Fortson and Mr. Cohen on Facebook. And how do you know that? because I'm familiar with Facebook. And it says for Robert Fortson, and then it's also identifying Mr. Cohen. And do those accurately represent the documents that you received from Ayn and Kevin? Yes. Mr. McClellan, Judge, the state would like to admit what's been marked as State's Exhibit 5. The court, 6. Mr. McClellan, 6. Mr. Hennessy, 6. Mr. McClellan, I'm sorry. Mr. Hennessy, preliminary questions, please. The court, yes. Mr. Hennessy, do you know how many pages is in 6? I do not. Mr. Hennessy, do you remember how many pages you received from the murder sheet people? Ooh. The murder sheet people. Yeah, we know about those. I don't know the exact number now. And then, so State Exhibit 6 reveals conversations between two people. Yes. Is Mr. Fortson deceased? Pardon me? Mr. Hennessy, is Mr. Fortson deceased? Yes, he is. Judge, I would like to object on hearsay. It's impossible for the defense to be able to cross-examination and confront the speakers. This is clearly communications between two people, neither of whom are available for cross-examination. The court, any response? Judge, the state does not believe it's hearsay. It's not going to the truth of the matter of the contents in the statements. It's going to show that there was a conversation and that there was a continued leak. That's just, of course, if they're trying to claim it goes to a continued leak, then the information in them have to be truth. If the court does deem it hearsay, I believe there's an exemption. If the court reads through the documents and reads through the statements in the document, there are several messages where Fortson says or asks Cohen to protect him from distributing the information. So he's already admitting that it is for the truth of the matter. And to delete messages once he knows the investigation starts. And so it's clearly statements against his interest in terms of trying to delete those messages and hide the evidence. And so the state would ask to overrule the objection. The court, all right. How show 6 is admitted over objection? Mr. Hennessy, I'm sorry. I would also belatedly like to add relevance, because none of those conversations are connected to either Mr. Baldwin or Mr. Rozzi. And there's no evidence or testimony that they were aware of the conversation, that they authored or authorized the conversations. So there's no connection to the two people that are shot with indirect contempt. Relevance. The court, you may proceed. So it's still over objection. Ms. McKinnon, thank you, Judge. Question. What did you do next in the investigation? After receiving this information, like I said, I did an audio videotape statement of Mr. Kane or Mrs. Kane and Mr. Greenlee, and then I contacted Robert Cohen. And did you interview him as well? Yes. And after you interviewed him, what did you do next? After I interviewed Mr. Cohen, I believe I interviewed Mr. Rick Schnee. And between the interviews of those people, did you have an opportunity to go through the documents that were handed over to you? Yes. And the interviews that you conducted with those people, did it match the information that you saw in those documents? Yes, it did. After you talked to Mr. Schnee, what did you do next? Mr. Schnee advised me that he had received objection, hearsay. Mr. McClellan, it's okay. There was no ruling. There was no ruling. Who did you interview after Mr. Schnee? Kyra de Bruin. And through your investigation, did you continue to gather information on how the photo were leaked? Yes. Was that the purpose in interviewing these people, to determine the source? Yes. And once you saw the messages from Mr. Fortson, did you attempt to interview him? Yes, I did. Did you attempt to interview him about the things in that document? Yes. And did he give you any information? No. Did you attempt to subpoena his Facebook records to get a certified copy of those documents? We did. And when you examined his Facebook page, were those messages in there? I did not examine his Facebook messages, but Detective Rector... Let's just call him Rector for the moment. There is... Oh, the names. Okay. He would be better. And after you attempted to interview Fortson, who did you interview next? I attempted to contact Mr. Westerman after I interviewed Mr. Fortson. And so the information that you got from the investigation At this point, where did he tell you the leak was coming from? Mr. Westerman. Did you know who Mr. Westerman was? Not at the time, no. Okay, did you investigate to find out who he was? I found out that he was... Mr. Hennessy, excuse me, preliminary question, please. The court, yes. Mr. Hennessy, when you said found out, did anyone tell you stuff? I did some investigation on my own. Mr. Hennessy, I'm sorry. I did some investigation on my own. Mr. Hennessy, yeah, but what did you investigate? I mean, did you read documents or talk to people? Yes. Okay, I'd object as derivative of hearsay, denial of the right to confrontation. Any response? Judge, I don't think it's hearsay for him to tell the court how he found out who Mr. Westerman was. I just don't think that hearsay applies. The court, so it's course of investigation. Yes, Your Honor. Okay, then overruled. Mr. Hennessy, I'm sorry, what was the overruled? No, I got that. But what did the court say right before that? The court, he said it during the course of the investigation, how he got to where he got. Okay. Well, there's no course of investigation exception to the hearsay rule. There hasn't been for about 15 to 20 years. The court, I overruled the objection, sir. Yes, ma'am. For fuck's sake. Question. And through this process, did you tell me about your attempts that you made to talk to Mr. Fortson directly? I attempted to call one of his phone numbers I had for him. I had two. And the first one said, "This is Robert Fortson. Please leave a message." I left him a message and identified myself as the state police, that I needed to talk to him about some information that came up in an investigation. And then I had another number. I did not know at the time, but it was actually to his father, Bob Fortson. And I spoke to Mr. Bob Fortson, and he said he worked at the Air Force Base and that he'd probably be up there, and that he would call him and let him know to get in contact with me. And so on or about October 10th. Did you go to the Air Force Base and attempt to talk to Mr. Fortson? Yes, I did. Did you gather any information from him? Very little. Did you ever attempt to get a hold of Mitch Westerman? Yes, I did. And does Mitch Westerman, through your investigation, did you find out if Mitch Westerman had a connection to the defense, Mr. Rozzi or Mr. Baldwin? I did. Tell me about that connection. He used to work for Mr. Baldwin as I'm not sure what he was employed as, but he used to work for Mr. Baldwin. Do you know if he's still employed by Mr. Baldwin? I do not believe he was, no. And that takes us to October 12th of 2023. What did you find out on October 12th? Yeah, they interviewed Keegan, Klein, and Fortson at the Air Force Base. Isn't that strange? It's almost as if they had a connection. I received a phone call from a sergeant with the Fishers PD that Mr. Fortson had committed self-ending. Yeah, right after Mr. Holman had a conversation, Mr. Fortson ended himself. At least that is what the medical examiner concluded. For you who just joined, I'm reading Mr. Holman, Jerry Holman, as his cousin, third cousin through inbred marriage. This here is Arthur Holman, but you can call me A. Holman. And were you able to gather any other information about the facts surrounding his self-ending? Fishers PD said it was obvious self-ending, and that during a conversation with his wife, he was upset because of the photos that he leaked, and that he wished he would just have been honest. Where's that fucking interview? Did you conduct any other investigation into his self-ending? No. Once your investigation was complete, were you able to determine the chain of how the photos were leaked? Yes. Can you tell me that? Mr. Hennessy, objection. Preliminary question. Was this based on stuff people told you? No, I don't believe so. Mr. Hennessy, was it based on documents that you read? Yes, more than likely. So basically, you're going to express your conclusion based on information. Yes. Provided by other people. Correct. Objection. Denial of right of confrontation, hearsay. Mr. McLellan, Again, Judge, this is through the course of an investigation. I'm trying to elicit from him a summary of what conclusion he found from his investigation into the leaked photos, Judge. Overruled. And so, Mr. Holman, can you tell me from your investigation, what were you able to determine how the photos were leaked? I was able to determine that Mitch Westerman, who used to work for Mr. Baldwin, was also in the Air Force with Robert Fortson prior. He wasn't at the time, but he was friends with Robert Fortson through the Air Force. And it appeared to me through my investigation that he was sending information that he was getting directly from Mr. Baldwin to Mr. Fortson. And Mr. Fortson was putting that information out to other people. That's a lie, folks. Mr. Holman here is lying to the court. What platform was Mr. Fortson using to disseminate that information? He was using Facebook and also Reddit. And did Mr. Fortson disseminate the crime scene photos that we previously admitted into evidence? Yes. And were you able to examine the contents of the conversation between Mr. Fortson and Mr. Snay? Is that correct? Mr. Snay? Mr. Cohen, sorry, I'm getting confused. Mr. Cohen, yes. And from that conversation, were you able to determine whether this was a one-time leak of photos or an ongoing leak? Mr. Hennessy, objection. Based on hearsay, it's an opinion, not a fact, and he should not be allowed to testify to it. The court sustained on opinion. Question. Through the investigation into the Richard Allen case, did he interview a professor at Purdue by the name of Professor Turco? Yes. And you interviewed him in September of 2023, is that correct? That is correct. Why did you interview him at that time? During the deposition with Mr. Baldwin, I mentioned that we have received information from a Purdue professor, but I did not know his name. You did? So I found out who he was and found out that they had never technically been interviewed, so I went and interviewed him. Fuck you, Holman. Fuck you all the way to hell. You interviewed him, and then you tried to bury it. And then you were caught, and then you re-interviewed him. Question. And you conducted that interview and then turned it over to be included in discovery for the defense, is that correct? Yes. And that interview was done in September of 2023. Yes. Isn't it weird, folks, that when they filed the Franks motion, which proved that Jerry Holman was lying about the Purdue professor, all of a sudden they find all of these reasons to re-interview people. Isn't that weird? And then from your investigation, were you able to determine if Fortson was talking about that interview? Yes, I did. And when he was talking about that interview, if you know? I know it was right after. Mr. Hennessy, I'm going to object. Will the court just show a continued objection to the testimony based on the conversation between two other people? The court, yes. Mr. Hennessy, Fortson and Cohen, thank you. Question. So you were able to determine when Mr. Fortson was talking about that interview between you and Professor Turco? It was within days. I don't know the exact date. I have to look. And was that information ever released to the public by you? No. Was that information to your knowledge? Was that information out to the public? No. Were there other instances during the course of your investigation where there are other instances that you found where Fortson was releasing information that was only privy to defense? Yes. Yes. Mr. Hennessy, conclusion, asked that it be stricken. Sustained. Hey, thank you, Conrad Schmidt. Thank you. Gifted 5 memberships. Yay, that is so generous of you. And it went to, hey, it's Ariel, Texas Any Soundwave Waves, Cassandra Durkin, Victor Mann, and Meta with a long E. Mita. Oh, Mita. Thank you so much. Now you guys have access to all my members-only content. You have early access to the videos I'm publishing. And you have your own emojis here on YouTube. And yeah, I still have to submit a fresh link to members only to my Discord. And hi, Ambrosia over at Rumble saying, oh my God, I was just listening, running errands, and I'm just glanced at the screen. What is this? This is Arthur Holman. He is third cousin by inbred marriage to Jerry Holman. You can call me A. Holman. Mr. Hennessy, because the answer came in so quick. I'm sorry. Sustained. Thank you. And stricken? Sure. Thank you. I don't have any other questions, Judge. Thank you. The court. Mr. Hennessy, thank you. Cross-examination of Lieutenant Jerry Holman. Let's see if Holman's memory is as good on cross-examination. Questions by Mr. Hennessy. Let me start where you stopped. So the Professor Turco report, the only time you've seen that is in this private discussion between Mr. Forts and Mr. Cohen. The only time I saw what? The only reference you testified to about the Professor Turco interview was in the conversation between two people, Fortson and Cohen, correct? Yes. So you didn't see it publicly disseminated out on the internet? No, I did not. So that was just contained in that conversation? To my knowledge, yes. And then back to Westerman. In your report, you did a report of your investigation? Yes. On just this, what we'll call the leak investigation? I did, yes. And the original report was 33 pages. I believe you. I don't know exactly how long my actual report was because there were other people involved in it. If you... And then, say the original was 33 pages, Then, with the attachments, it turned out to be 272 pages. Yes. Okay, now in there, you placed Mr. Westerman's affidavit that was filed with the court. No, I don't know what you're talking about. You don't think you did? My affidavit? Westerman's affidavit was filed with this court. Have you ever seen it? Yes, yes. Okay, so you know that he took photos of stuff, but didn't take the actual stuff, discovery materials. That is correct. And Mr. Baldwin had no knowledge that he had done it. Yes. And that he did so without any authority for either Mr. Baldwin or Mr. Rozzi. That's what he said, yes. And there is no evidence that Mr. Baldwin or Mr. Rozzi authorized Mr. Westerman to share anything with anybody. That is correct. And then, were you involved in seeking the prosecution of Mr. Westerman? Yes. And then, so you had a conversation with Mr. Hamner, the elected prosecutor of Johnson County. I did. And that's where Mr. Baldwin's office was. Yes. And that's where Mr. Westerman purloined yes, by photographs, correct? Yes, sir. And then he passed it to a special prosecutor. He did. And then you also discussed seeking charges against Mr. Baldwin. I did. And none were ever filed. No, none were ever filed. And then, I wish I'd stop saying and then. So there's 5 photos that you received from the murder sheet people. There were more than that. Okay. But 5 in evidence. 5 that I believe were from the crime scene, yes? Yeah. Now, you said you recognize some of them from having viewed them at deposition by Mr. Baldwin and Rozzi. Yes, sir. By the way, folks, the murder sheet people, why the fuck would the defense leak to them? Why? There's no reason for the defense to leak to them. On contrary, they would avoid at all cost to leak anything to the murder sheet people. Let's continue. When you saw the one that has the blackout, the circle, did that have blackouts at the deposition? Yes, I believe so. I'm sorry. And then you said something about a side-by-side. I did. Side-by-side of what? If you can say without revealing too much, because it's under seal. Sure. There was a side-by-side. Half the paper was a picture of Abigail, and the other was a picture of an asterisk. Of a who? Like an asterisk, like a star. Now, you talked about your attempt to get a statement from Mr. Forston. Yes, I did. And did you threaten him with jail? No. Do you remember giving a deposition on March 1st? I do. And have you reviewed it? I did. You had one. I didn't sign this because there was... What do you say? I did not sign it because there was missing information and false statements in there. What do you say? I did not sign it because there was missing information and had false statements. Incorrect. Well, yeah, I'll give you it was incorrect, but I don't know. False is a little strong. Incorrect. And it was a transcriber. And so when you received it, you had the positions before. Yeah. So when you received it, there was an errata sheet. Uh-huh. Correct. Did you? And then, so the process is, if you make mistakes, you go to the errata sheet, you correct them, and then you sign your errata sheet. I fill it out, but I told the prosecutor said there was a lot missing. So I don't know, it was just not transcribed, but I wasn't going to sign it because it was the first part of the position was missing. Right. Yeah. But the part that was there, you could have ascribed to. Sure. Okay. All right. Oh, may I have a moment? Sorry. I'll come back to that. Did you tell Mr. Fortson that he could be held in contempt of court and or charged with obstruction of justice? Yes. Did you tell him you can get the judge on the phone immediately? No. You didn't say, quote, let me call the judge real quick. I did say I'm going to call the judge, yes. And you said, I'm going to call the judge, let her know, and see if she wants to issue an order of contempt, correct? Yes, sir. Then you went out of the room. I did. Did you call the judge? I did not. Did you tell Mr. Fortson you could call the judge? So I'm in the military. No, you're a cop. You're not in the military anymore. So I have a chain of command. I was brought up that way. I called the prosecutor first. I've never done a contempt. So I thought I was going to have to give the information directly to the judge because she ordered it. So I talked to the prosecutor and he said he would forward the information. That makes fucking McLeland a witness in providing false information, lying about what a judge can and cannot do. Why did you give Mr. Fortson the impression that you had the ability, the judge's phone number, and could call her immediately? I don't believe I did. Well, when you said, let me call the judge real quick, what impression do you think a person would have? I said I was going to call the judge, yes. Yeah, so what do you think a person's impression of that would be? Mr. Leland, objection, judge, cause for speculation. Question, this guy has the ability to call the judge, right? The court sustained. Question, did you tell him it would ruin things for Mr. Allen? What's that? Did you tell him it would ruin things for Mr. Allen? Yes, I said it would ruin things for everybody, yes. And then you said that it didn't, and I quote, it doesn't bother me any, because it's all bullshit in my opinion. Yes, sir. And then you told him that you had gotten information from Mark Robert. Yes. Who you later learned was Mark Robert Cohen. That is correct. And a K. Smith. I believe I said K. Smith or Kyra, which I was confused because both of those names come up, so I wasn't sure if that was the same person or if it was a different person. But later I identified that person to be actually before that, but I forgot that person was Kyra De Bruin. So you don't believe there's a K. Smith that exists? If there is, there probably is, but I do not know her. I've never spoken with her. Okay. I want to go back to my question about, did you threaten jail? Okay. And on page 14, the question was, didn't you indicate to him that he could go into jail over this? I did. Okay. I did indicate it. I said it's a possibility that a judge could order a contempt. It's what I said in my interview. So yeah, you told him you can go to jail over this. I didn't threaten him. I told him that there was a possibility he could. You fucking retard, Holman. You fucking retard. Question, well, I was just being upfront. Question, your opinion, it's not a threat. Would you admit that some people might take that as a threat? Mr. McLeland, objection, judge. Okay, this calls for speculation. The court sustained. Do you recall Mr. Fortson telling you that he wanted to have some consultation before he talked to you? He did. And at first, he simply said consultation. No, he said that he thought he needed to talk to somebody. Right. And then later, he specified attorney. Yes. And you kept talking to him. I did not ask him question, but I was explaining to him that I was there for, and yes, but I didn't ask questions until after I talked to the prosecutor. And then you asked questions? I asked him, I think, one question, and that was is he not willing to? Maybe a few. I don't know. I have to take a look, folks. That is in breach of any Miranda rights, because who is talking to here is not. Yeah, I Jesus Christ. Yeah. But I asked him if he was not willing to give up the information that I knew he had, and he said, not without a lawyer. I said, that's fine. But had he had invoked counsel before then? Absolutely. And you took a recorded statement from a Miss Ehlenfeld? I did. And she had some pictures. She has some pictures on her phone, yes. Did you see them? I did. Did you connect them to any of the other pictures? Yes. Which ones? I don't recall exactly which ones, but it should be in my report that there were ones that were released by Mr. Fortson to Mr. Cohen, and I had her delete them. You had a Jerry Holman, you had a potential witness destroy evidence? How about that? But she told you that she got them from a Tyler Carpenter. Yes. And who is he? I don't know. You can never find him. Nope. What effort did you make? What's that? What effort did you make to find the source of the photos, Tyler Carpenter? At that time, I talked to the prosecutor, and that time we weren't interested in all the people that had him because we'd already located the source and where they came from. If there was only one source, correct? To my knowledge, yes, there was only one source, but that's your belief. Through my investigation, I only located one source. Right. Yeah. But so what you had at that point was your belief that Westerman obtained these pictures without permission, correct? Yes. And that he gave them to one person only, Mr. Forston. Yes. And that Mr. Forston gave them to Mr. Cohen and Mrs. De Bruin. Kyra told you. Kyra? Oh yeah, I'll get there. So you had no interest in knowing who else had them. We had a lot of people that had them, and at that point, nobody was releasing them. So we got the word out that there could be a potential consequence if they did release them. So after talking to the prosecutor, well, in all of your interviews, you told them that the judge was adamant that you find the photos and get them or delete them. Have them deleted, yes. And every person that you did talk to, that you identified in the chain, you talked to them about contempt. I talked to them about what? Contempt. Yes, possibility. So from that, you learned that the Tyler Carpenter allegedly had them. No, Kyla De Bruin. No. Who? Tyler Carpenter. Kyla? Tyler Carpenter. I don't know. You just admitted that Mrs. Ehlenfeld told you she got them from a Tyler Carpenter. Are you saying Tyler? Tyler. Yes. Carpenter. Yes. So what was the confusion? I thought you said Kyra Carpenter. Oh, it was Kyra De Bruin. For fuck's sake. And you were charged with getting those photos, but you didn't locate or attempt to locate Tyler, who allegedly had them, because, well, you'd already found out who you believed what the source was, correct? Yes. And you made that decision in conjunction with Mr. McLellan. What's that again? You made that decision in conjunction with Mr. McLellan. Yes, I did have a discussion with the prosecutor. And then Miss Ehlenfeld told you about a screenshot somehow connected to a George Rye, who was former law enforcement. Do you recall that? It was a separate investigation, but yes. And what was that investigation? Was that investigation not related to leaks? Correct. That investigation, the information she was giving me was not related to the leaks. What investigation was it related to? Harassment. Harassment? Harassment. And then she told you she had sent them to Christina Mack. She sent the photos to here, the photos? Yes. And so did you go talk to Christina Mack? No. So she might still have these photos. She hasn't released them, so she has not released them. If she does, I think most people Well, you haven't seen that she's released them. Correct. You don't know how many people she maybe sent them to. That is correct. And the same with Tyler Carpenter. He might still have them. Yes, sir. And then how many photos do you believe Westerman took? I don't recall exactly what he took. There were some that looked like they were downloaded from another Facebook page. I think he probably took, I'm sorry, without... I have to look at the photos to give a number. What did you say about downloaded from a Facebook page? There were some downloaded from somebody's Facebook page. By Westerman? I don't know. They were just sent to Mr. Fortson. I'm sorry. They were sent to Mr. Fortson, to Mr. Cohen. I don't know who. Oh, so Mr. Fortson maybe downloaded other pictures from Facebook? Could have, yes. And did Mr. Fortson, to your knowledge, have other sources for photographs and information on the investigation? To my knowledge, no. So in his conversation with Mr. Cohen, he doesn't talk about other people. Can you repeat that? Who doesn't talk to other people? I'm sorry. Can you repeat the question? You said you reviewed conversation between Fortson and Cohen. And so my question was, did Fortson talk about other people? Yes. Okay. Did they ever mention Mr. Westerman? Just Mr. Baldwin. He mentioned Mr. Baldwin. Fortson? Yes. Mention Mr. Baldwin? Yes, sir. In what respect? In the screenshots of the text messages between them, he said, Mr. Baldwin told me I was going up to Allen County. Mr. Baldwin told me this. Mr. Baldwin told me that the crime scene was going to be... You're saying that Fortson claimed that Mr. Baldwin had direct conversation with him. That's what it was alluding to, yes. You ever corroborate on that? I tried to. With what? Phone records? No. I tried to interview Mr. Fortson and Mr. Westerman. Right. And you didn't. You had Detective Rector interview Mr. Baldwin. What? What? Could you repeat the question? Yes. You had Detective Rector interview Mr. Baldwin. Yes, I did. For 2 hours. I don't know. I wasn't there. You mean you haven't looked at it? No. And did you say, hey, ask him about Mr. Fortson? I don't believe I told or Detective Rector how to conduct this interview, no? Did you get a download or the forensics examination of Mr. Fortson's cell phones and electronic devices? Detective Rector did, yes. And so you have reviewed those phone records. Just in discussion with Detective Rector. What you say? Just in discussion with Detective Rector. Oh, any corroboration that Mr. Baldwin ever spoke to Mr. Fortson in the phone records? I don't recall, but that'd be a great question for Detective Rector. Mr. Hennessy, don't go anywhere. Now, early on, the discovery of the victims. There was a leak from a search party member, correct? Yes. Objection, Judge. And that, Ms. McClellan. Again, I'm not sure where you're going with this line of questioning. Mr. Holman answered before I could object. But I don't know that this is relevant to what we're discussing today, Judge. I don't think it's relevant to these proceedings. Mr. Hennessy, I'll tie it up, the court. And if you don't, I'll argue why it's relevant. The court, I'll give you a little leeway, but it needs to be tied up. Question, that leak was crime scene photos. Yes, well, no, it wasn't a crime scene yet. Because the search party had found them, so we didn't get to them yet. So it couldn't have been a crime. Are you fucking retarded? Yes, he is. Detective Coleman is actively retarded. Him claiming it wasn't a crime scene yet when 2 missing girls are found dead is ridiculous. Right. It couldn't have been a crime scene yet. It wasn't a crime scene yet because the search party located it. It wasn't a crime scene until we got there and secured the scene. It is always a fucking crime scene, you cunt. And secured the scene. But it was photos of articles that eventually were in the crime scene. Does that make sense to you, sir? Not really. Okay. Because there were photos of the girls? No. And the sticks? I never saw those. You don't believe? Mr. Hennessy, may I have a moment, Judge? You may. Mr. Hennessy, what? I said you may. Question. In your deposition, at page 8, under oath, on March 1st of 2024, you indicated that the leak from the search party member had some text messages and some photos of clothing. Yes. And you're not calling them crime scene photos. Why? Because it was before the police was notified. It wasn't a crime scene until we got there. This is so... Jesus Christ. So you're saying civilians found the girls first? Yes. So then he took pictures before law enforcement got there. That is what I believe, yes. And then he publicized them. Mr. McLean, Judge, I'm going to object at this point. I'm failing to see how he's tying this up and how it's relevant to the contemptuous information that the state has filed and the point of this hearing, Judge. Mr. Hennessy, there were other crime scene photos out there. I mean, he's technically saying it's not a crime scene because law enforcement hasn't shown up. But it was the scene of a crime, and some other guy, way before these defense attorneys was appointed, had photos of clothing and other things. We don't know what. So yes, I think it's relevant because that was out in the public arena long before any photos from Mr. Westerman. The court, these weren't crime scene photos taken by the police? Correct. The court, okay, then it's not a crime scene. What they are trying to tell us is that it cannot have been a crime scene until the cops got there, which is absolutely mind-blowingly stupid. Because with that argument, they cannot backtrack a crime. It might not be officially a crime scene, but it's still a scene of a crime, making it yeah, Slew the Goose said the crime scene exists as soon as the crime happens. Doesn't matter when you find it. Thank you, Sleuthy. Mr. Hennessy, what you say? The court, then it's not a crime scene, not crime scene photos. There may be photos taken by civilians, but it's testifying that they were not there yet. Mr. Hennessy, correct, but it's the court, so they can't be. Mr. Hennessy, picture. Crime scene photos taken by police. Mr. Hennessy, but it's pictures of the scene of the crime. And if you put them out in the public, you're not going to be able to discern when the police showed up, whether these are police photos or other photos, but they will clearly be, to the public, pictures of the scene of the crime. Kaya Salpinko, hello. This is why I don't get out of bed in the morning. Yeah. Mr. McLean, Judge, we're here to discuss the photos that were leaked from the defense. I don't think there's a debate about that. And I've got some additional documents to file that I would ask the court to take judicial notice of. Of course you do. I don't think there's any debate that the crime scene photos that were leaked in this situation came from the defense. The defense has admitted that. No, they have not, you fucktwat. And so now Mr. Hennessy wants to say, well, I'm not sure what he wants to say. He wants to say that there were other photos taken, and since those were leaked, the ones leaked by the defense are no big deal, is what I think he wants to say. Mr. Hennessy, well, Mr. McLean, but I'm not sure. But I don't know how that's relevant to the crime scene photos that were leaked in this instance. The court, how are these relevant? Mr. Hennessy, because they need to establish that Mr. Baldwin and or Mr. Rozzi publicly disseminated what they alleged. And it goes to the weight of their evidence that, in fact, there were other sources of photos of the scene of the crime. The court, and I will give it the weight that it deserves, sir. Please proceed. Mr. Hennessy, thank you. Question, and that was investigated by other people? Yes! And the fellow that had the pictures, law enforcement just told him not to do that again. Correct. Nobody reported it to the prosecutor, to your knowledge. To my knowledge, no. But more than likely, they probably discussed it. I'm sorry. That would have been the former prosecutor. Oh, you'd have to ask him. Mr. Hennessy, Judge, that's all I have from Sergeant Holman at this time. The court, Mr. McLeland. Thank you, Judge. Redirect examination of Jerry Holman. Yeah, I keep forgetting. Pink Slime, I know. Hello, Pink Slime. Thank you for being a member for 10 months. Thank you so much. Questions by Mr. McLeland. Lieutenant Holman, Mr. Hennessy asked you if there was any evidence authorizing or evidence showing that Baldwin or Rozzi authorized to share anything to anybody. You recall that question? I do. And from looking at the documents of the conversation between Fortson and Cohen, were you able to find evidence the leak was ongoing? Yes. Hennessy, objection. Hearsay, it's an opinion, it's a conclusion, it's for the court, not for the police. If they want to pull out evidence, conversation, even though it would be objectionable for hearsay, that would be overruled. If they want to point to specific facts, then it allows them to argue to the court the conclusion that it was ongoing. That would be proper. But to simply ask this detective, did you find, what evidence? Did you just find evidence that the leak was ongoing? Leak from who? To whom? So I object. Relevancy, a conclusion of law, actually, and an opinion not supported by facts that are currently in evidence or identified to the defense. Mr. McLean, Judge, the state believes Mr. Hennessy opened the door at this point for us to be able to talk about the contents of the messages. What? He asked if there were any evidence authorizing, or from Mr. Baldwin and Rozzi, authorizing to share anything with anybody. He also asked if the detective was able ever confirm, or was it ever able to see if Fortson had mentioned Baldwin's name, if he had other sources. And so with those questions, Judge, I believe he opened the door for us to talk about the contents of those messages, and the state would like to do that. Mr. Hennessy, I would agree. If they want to point to something or a number of things within the conversation that allows the court to conclude the leak was ongoing, where they identify sources in the document, it's in there. But they can't just simply say, hey, you read this whole thing and you found out the leak was ongoing. That's not a proper question. Judge, overruled. Mr. McLean, Judge, I guess I withdraw the question and will just point to specific facts or specific conversation within the exhibit that's been admitted. Of course you do. Of course you do. So even Mr. McLean, this can hit me in the ass. Question. So, Mr. Holman, I'm going to show you what's been admitted as State Exhibit 6. Now, you testified earlier that this is a conversation between Mr. Fortson and Mr. Cohen. And so I'd like you to read on page 1 here, the first message I'm directing you to. Can you read that? Read it to yourself. Are you familiar with that message? Yes. Can you read to the court what it says? It says, what's up? Same rules? Let's get permission to share anything outside of our convo and respect any notes. And that message is from who? Who's sending it? Robert Fortson. I want to draw your attention to the next page. And this conversation here, you can read to the court. Mr. Hennessy, I'm sorry, what page? Well, they're not marked. Here, I'll show you. Yeah, I know. Okay. Question, and can you read the message to the best of your ability to the court? It should be next weekend. I'm sitting in Franklin with it all. They want me to. And they want me to punch holes in all their stuff and look at it. And that message is from who? Robert Fortson. Where is Mr. Baldwin's office located? Franklin. Lieutenant Holman, I ask you to take a look at that message. Can you read that message to the court? Mr. Hennessy, not. Judge, I'm going to object because this particular message is no connection to. I can find it. Because they didn't number these things. The court, the exhibit is in. Mr. Hennessy, what do you say? The court, the exhibit has been admitted. They are allowed to discuss the exhibit that is properly before the court, sir. Mr. Hennessy, well, the court, you may continue. Mr. McLeland, thank you. Can you read that, Mr. Holman? Yes, sir. Defense just got the girl's phone records. No details yet, but they're saying that there is good stuff in there, or the stuff good on there. We'll go to the next page. Can you read that message? This one, it's the same one. Okay, so same message were recorded. Who is that message from? Rob Fortson. And so Fortson is saying that the defense just got the phone records of the girls. Yes. Okay, I'll draw your attention to this message. Can you please read it into the record? Purdue professor said the exact opposite of what Holman said. Andy has the audio from it. Mr. Hennessy, I'm sorry, The Purdue professor, who is still there, mind you, consulted with the Harvard professor and said, yes, those are runes. Yes, it's a cult-related stuff. So digest that for a second in the grand scheme of the police work. And who is that message from? There's more. You want me to? Go ahead, I'm sorry. Sorry, I'm a slow reader. That's okay. Judge has said she's going to set a suppression hearing, but Andy's looking for clarity on it. That means Frank's hearing, or what she's meaning for sure. We shall see. I'll watch that now. That's from Robert Fortson. And what is the date of that message? October 2nd. Mr. Hennessy, may I see that page? Mr. McLeland, sure. Thank you. Mr. Hennessy, thank you. Again, Lieutenant Holman, when was the date of that message? October 2nd. And when did you conduct the interview of Professor Turco? In September. I don't remember the exact, but then I turned it over a couple of days before this to you. Did you ever release that interview to the public? No. No, but Mr. Holman, there was already information that you had talked to the Purdue professor, and then the defense found out that you lied about what you talked to him about. So all of that, Jesus Christ. Did you release it to anybody but my office? No. And are you familiar with somebody involved in this case that goes by Andy? Yes. Who? Mr. Baldwin. What's Mr. Baldwin's first name? Andy. Okay. Mr. Hennessy, Your Honor, may I go over there so I can read those, what they're going to show you, so Mr. McLeland doesn't have to come back and forth? The court, certainly. What do you say? Certainly. Thank you. Lieutenant Holman, I'll direct your attention to this. Can you read this message? I thought about a way I could show you the crime scene without sending the pics. Maybe photograph something with the pics on my phone in the photo. And who's that message from? Robert Fortson, who is directed to Mr. Cohen. Mr. Rozzi, Judge, I couldn't hear who he said it was directed to. Could you please have him repeat that? It's a little tough to hear back here. Sure, but I'll ask the question again. Who was the message from? Robert Fortson. And who was it directed to? Robert or Mark Cohen. Mr. Rozzi, thank you. Will you read this message, please? Facebook, you have no worries about it. It's technically crime scene and a big piece of current evidence. Who is that message from? Robert Fortson. And then, could you read this series of messages, please? Go side by side with the Barbara one. Make it a poll. Ask F, Rune, Spatter, other. 4 options there. Tell them to list their other in the comments. I'll also let them argue it if it's actual F. That's from Mr. Fortson to Mr. Cohen. Folks, what is happening here is he worked for Mr. Baldwin. They are allowed to discuss the evidence. Baldwin did not know that this person shared the information with others, and they certainly did not authorize the taking of pictures. So throughout your history as a law enforcement officer, you've had an opportunity to investigate several crimes. Is that correct? Yes. And you had an opportunity to read those messages and go over the entirety of State's Exhibit 6. Is that correct? Yes. From your investigation, what conclusion did you draw from that information? Mr. Hennessy, objection, improper question. It's not for the witness to conclude, and it's summing up. The court overruled because of course she does. Mr. McLeland, I rephrase that question, Judge. That's fine. Overruled. Why are you trying to rephrase question when she's overruling the objections? Is it because you know it's improper and you might try to correct the judge? Lieutenant Holman, were you able to conclude from those messages that the leak was ongoing? Yes. Mr. Hennessy, there's no difference than the very first time he tried to do it and the court sustained the objection. And then he just backed it up and slipped it right in by me. And Mr. Holman answered like really, really quick. So I object. Ask that it be stricken. Sustained. I'm sorry, sustained. Stricken? Certainly. Thank you. Everybody has to remind the judge on what her previous rulings were. Lieutenant Holman, the messages you read, do they correspond with events that were happening during the course of your investigation? Yes. Meaning information was being leaked? Yes. To your knowledge that you know of, did anybody else besides defense have that information? Not to my knowledge, no. Specifically the Professor Turco interview that you had done days before it was leaked by Fortson. That was the second interview. Lying sack of human garbage. Yes. And Fortson is directing Cohen to push this stuff out to the public. Is that correct? Yes, he is. And from the text messages, why you see, what is the purpose of pushing it out to the public? To get their opinion. Mr. Hennessy, to do what? To get the public's opinion. Mr. McLennan, I don't have any other questions, Judge. Thank you. The court, Mr. Hennessy. Cross-examination. Question. Mr. McLennan started to say, and he said, quote, we're going to go through these individual pages to establish a connection between Mr. Baldwin and Mr. Fortson. You remember that? Yes. And so, Mr. Fortson, first off, do you know anything about Mr. Fortson's credibility? No. Did you know that he pretended to be a lawyer? I have no proof of that, no. Well, Mr. Cohen told you. He said Mr. Cohen said he thought he was. No, he said he represented himself as an attorney. As an attorney, yeah. What do you say? I think you're correct, yeah. Okay, so was he an attorney? No. So there's a false statement, correct? Yes. At least one false statement from Fortson. Yes. And then he said he's sitting in Franklin, but doesn't say where. Correct. And do you know where? If Mr. Westerman had connections to Franklin. Do I know if Mr. Westerman has connections to Franklin? Other than Mr. Baldwin? Correct. No. Do you know if his girlfriend lives in Franklin? At the time, I did not know that, no. Do you know if Mr. Fortson would meet Mr. Westerman in Franklin? No. And then you said the defense got the phone records, correct? You read that part? I read that, yes. Didn't say that. That had no reference to Mr. Baldwin, did it? I don't think so, no. And then he said, with regard to the Professor Turco, he said, Andy has the audio. Yes. How do you know Westerman didn't tell him Andy has the audio? More than likely that was happened, yes. So that's not necessarily direct contact between Mr. Fortson and Mr. Baldwin. No. And then, shows the crime scene. There was no reference to Mr. Baldwin in that one you read, correct? Correct. And then the Facebook, no worries, crime scene, big piece of evidence. There was no reference to Mr. Baldwin. Correct. And then, so there's only one time Fortson says Andy, and he doesn't attribute it to Mr. Baldwin. It could have been Mr. Westerman. That we discussed, yes, sir. That'd be what? There's actually more references to Andy in there, but we didn't go over them. But nothing Fortson saying, hey, I'm with Mr. Baldwin. No. Nothing saying, hey, I talked to Andy directly. I'd have to check on that. Okay. And then you read one about a Barbara. And you're familiar with Barbara McDonald having leaked Professor Turco's report? No, I'm not. Did you not investigate that? No. And so you say, Fortson, I'm sorry, you say it was in your opinion or belief that somebody wanted to release this stuff to get the public's opinion, right? That's what it said, yes. Who? Was that Cohen or Fortson? It was Fortson. Okay, so he never said, I want to, you should put this out there to damage the prosecution. Did I what? What? Could you please repeat the question? So he never said, put this out there to damage the prosecution. Who? Fortson, the same guy who just wanted to get the public's opinion. Not to my knowledge, no. Mr. Hennessy, okay, that's all I have for now. Thank you, Lieutenant. You may step down. Thank you. The court, could you just give that exhibit to Jody, please? You may call your next witness. Judge, before I do that, I have a few more documents I'd like the court to take judicial notice of. I marked them as States Exhibit 7, 8, and 9. 7 is an email from Mr. Baldwin to the court dated October 9th of 2022. Number 8 is a letter that Mr. Rozzi filed with the court, and that's in the CCS. And then number 9 is the affidavit filed with Mr. Westerman in the CCS in this case, Judge. The court, I'm sorry, that was 7. If my 7 was an email of Mr. Baldwin directed to the court, to myself and Mr. Rozzi. The court, okay. On October 9th, I believe, Judge. Any objection? No objection to the admissions of 7, 8, and 9. Okay. Without an objection, 7, 8, and 9 are admitted. Oh. Now, when Holman is gone, I can take that off. Ah. All right. We are 3 hours in, and I have to save Ben Rector to tomorrow. Let's see, the 4th is tomorrow. There might be a hearing I'm interested in live streaming tomorrow. But next time on the Delphi Transcripts, we will go through Detective Ben Rector and the rest of this day. The rest of this contempt hearing. Whew. All right. Yeah. So inadvertently, through this, we now know that Holman is a liar. Well, we already knew that, but now we have it black and white here. We know that he actually never did, but he only investigated enough to draw a false conclusion, which he apparently is what that is his MO. He only investigates things that, hey, you need to find things on these two people, and that is all he does. That is, and we know that Judge Gull has to be reminded of her rulings. We also here we know start to see her MO in denying without hearing everything that comes from the defense, and it's appalling. It's absolutely appalling. But that is what I had for you today. There's a hearing tomorrow. I don't remember what it is. The 4th. Well, if it isn't one tomorrow, I will continue with this. But, folks, from me and Mr. Jingles, thank you. Thank you for staying with us, with me, with all the other content creators during this trial transcript. Follow us all, like and subscribe to us all, make this hit the algorithm more. And yeah, as I always say, finish off with, hug your family. Unless they are shit, then screw them and give your love to the people who deserve it. I'm going to send you off with a free Rick Allen song. Have a good one. I will see you guys tomorrow. Bye-bye.
Down in the shadows where the courthouse stands, a gavel cracks a fading hands. Judge Gould, they whisper with a crooked grin, played the game where justice don't win. Free Rick Allen, let him go. Chains on the innocent, don't you know? When the truth's been buried and the lies unfold, the fire in the people burns hot and cold. Prosecutor McLean with his papers tied wrote the tale that never saw light. Twisted words in a room of stone, left Rick Allen to stand alone. Who will answer? Who will pay? The sun don't rise on a judgment day. Free Rick Allen, let him go. Chains on the innocent, don't you know? When the truth's been buried and the lies unfold, the fire in the people burns hot and cold. Officer Holman, eyes like frost, drunk on power, the line got lost. Lock the doors, keep him inside, for justice limps where his footsteps stride.